Last week the last working day also. If possible, 8 week minor next week. Phrase that you said nothing. My mom, my other day patient. I don't know. My contract to me. After my contract, he lost the guy to be lines. Started with a man sort, and you're not in the tomorrow. Similar to the phrase that we should summarize. It is not action man. This will come to motion mission methods. We can address mission matter. Mission means admission to schools. Not admission to be forced. What do they ever do? Because there is no study going on. Before saying, my lord, there is concern 22nd. But they agree from the same. But this instructor, my lord, hospital structure, the instruction is going on. That's the one of this. So this may kind of check up tomorrow. Otherwise, sin. Yes. Yes. How can we not function tomorrow? How can we not function tomorrow? That's the function on 22nd. So then we go. It will come before the same day. Yes, correct. As per maximum. Tomorrow, because the restructuring is going on. So that is it happens to be part of. Other than it function, not function tomorrow. So they have functions too. Yeah. No, only 22nd, my lord. Day after tomorrow is also portal. My lord, 19th is the post, but 19th is there will not function. That will function on 22nd. Why? It is a sitting day. 29th sitting day. Plus 3 intimation is given and when it was 111 and 22nd is the last day. March and original certificate was presented by the school. Biggest school from 920. Miller termination matter Miller. When it was Miller to the year 24. One gross matter we have taken up next week for amendment. Amendment. What is that? Originally, the notice has been issued, but some persons have opted. Yes. My lord, weekly list to except the government or lawsuit order there. It was listed on 19. Not your lawsuit order is the government. Government. No lawsuit. My lord, weekly. My lord, pardon me, lord. That termination matter that is covered by judgment of this judgment. Let's. So we learn next week. Next week. Permitted to mention Miller weekly list item 220 Miller, 220 Miller. The lordship has specifically on 21st August 2025 directly. There is a case fiction where a young contractor allotted some work, completed recommendation was made for payment. Direct to come with the checks, but it has not been any day your lordship convenient. 220 Miller. 220 daily list. My lord, was this. But I think number 149. It's a pension return, my lord. Which year? 2024. Immediately. I mean, it's an old lady of 81 years old. Nothing will happen. But I thought the year old and I can 153 blood came. The petitioner is on blood since number. Petition number 1806 was 2015 minor. 2015 minors. Immediately. I thought of item 153 years. So there are minor choices that will static pension. They're studying for immediately. The matter in the list. The matter in the list. One other person. List is taking weekly list. Item number 166 the weekly list. I'm requesting to take upon 23rd. 23rd? Which year, man? 24 months. 24. What's the agency? That's what listed to be the regulation of the solid parts. Immediate application. Can it be taken? Can it taken on supplemental list? Urgent matters to be taken. Yeah. So let's read this item 112. Yes, means if it will be taken off to take because on the last two occasions, people are waiting in the queue. Why you come to jump the queue? They will ask, why you are drifting case? Because the 2019 case, madam. The 19 case. Yes, madam. The state was supposed to provide us some money. That is. Some supplementals were directed to listed in 19 in Hon'Ble Justice. But Hon'Ble cannot be functioned to they finally argue. Same thing. Yes.
Lordship, I may be excused. Lordship, I'm in virtual mode.
Completed. One post-election picture that is almost more than 1 year. So I pray that it will take 5 to 10 minutes to amendments immediately. Every case I did not take for that date. Any date, after immediately after. Yes, personal time. I'm just preparing.
Which is that time for me. This contempt matter. Salary not released despite the order of this honorable court. And on 15th, like I mentioned, or this was enough to list it on today. Somehow it has not come.
Salary and part.
Yes,
Very clear to list. It's a matter of 22 minor. Letting it completed. 6 it's for last 10 something working. Immediately.
Maintenance
But is it bidding matter or
improvement of pictures and because this counter has not been filed by here.
no immediate application? You can take advantage of not paying people.
Supplementary item 1.
may I please, madam?
Yes.
Madam, the reputation is of 2-decade old, madam. The history involved is 4 decades old. Madam, to assist your lordships, at that time the lectures were not filed. To assist your lordships, I have prepared the check with my abdomen, my lord.
And I minus minus I know that minus settlements once it begins minus will not stop. Yes. Right frequency was dismissed for default in 2022. Now in 2024 it was restored. After I Hon'Ble record, if I take it up in the meanwhile also, what my learned friend says, there is a question of laying up a road and retention of the wall. The development in India is being developed by developers, not the development of the design minus because brief. Whole is for the internal improvement trust. In the meanwhile, lot of development has taken place. I'm going to take instruction whether it is required.
What is my humble submission? Yes, madam. My trigger, madam. My submission. Today I will not start. Today I will not start. May I lose the madam? My humble submission. That's why, madam.
No, I don't want you to use the way.
I am being permitted to start. Let him take issues because, my lord,
No.
during the CMA period,
19 years we did. 19 days you not need.
my written notes were taken into record.
Yes.
I'm serving
That means that
Yes. Serving it on BDM. madam. Yes, madam.
The sequence of events by this. The insistence that the matter should be taken immediately is taken.
One humble submission, my lord.
Yes.
When the honorable judge restored the matter,
Yes.
he refused to restore the writ with its interim order, my lord. Because honorable judge observed that the CMA appeal is before me, not the writ. I humbly pray when the BDA is praying for taking time, why the interim order at least maybe.
That 1 year ago.
Yes, but that is my prayer, my lord. It is my duty to bring your lordship notice, man.
Of this matter on the 9th of October. On 9th of October, at the request of the progression at the request also.
Item 2.
Item 2, may I please, Your Lordship? Your Lordship, I'm appearing virtually, Your Lordship.
Ah.
Your Lordship, these are the matters filed by the demonstrators, Your Lordship, for the grant of benefit of RACP benefit, Your Lordship. Some of the matters RACP has been paid for, and some of the matter, Your Lordship, UGC benefit has been paid for.
Any
However, it
representation
is,
is made.
Your Lordship.
Any represent? Why are you not coming before the court? You are a young lady, gentle lady, and many people who are plus 90, they are coming to court.
Your Lordship, I was badly placed today, Your Lordship.
Not today. Every time you are online.
Yes, Your Lordship.
Many old people, they come with all difficulty, and the president of the Bar Association himself is here every time. What happens is the true justice cannot be done. You say something, I say something, communication gap takes place, your clients will be affected, and youngsters should come to the court. They should not spend time elsewhere.
Yes, Your Lordship. I beg your
Therefore,
pardon.
we'll dismiss these matters today. You file restoration application, thereafter we'll look into.
No, Your Lordship. I beg your pardon, Your Lordship. I'll be in the court, Your Lordship.
Yeah, never you have come to court. What impression it gives? Although you are entitled to argue, but when communication problem arises, that's not welcome. Or those who are not well, who are aged, who are very senior and they feel a lot of they cannot spend time in communication. For them we can. Are you from Delhi?
No, Your Lordship. I
You are
am.
not from Delhi. You are
Your
from
Lordship, I have some personal difficulty, Your Lordship, in coming
Delhi.
to the court, Your Lordship.
Okay. Any representation is made in these matters?
No, Your Lordship, representations have been rejected. I'm challenging the rejection orders, Your Lordship.
Rejection
In
order?
similar,
We have already.
Although similar matters are there, they have been
yes, Your Lordship.
notice be issued. This is with the rest.
Notice, emergency notice. That is the EG notice for the ROPs.
Yes, Your Lordship.
ROPs are
Except opposite part number 5, that is Accountant General, Your Lordship.
in all these cases, OP number 5.
Yes, Your Lordship.
Emergent notice to OP number 5. Call along with WP number. Which is
Along
the
with
WP number?
22638 of 2025.
22683.
638.
22638 of 2020. Okay. Next.
Item 3.
Obliged, Your Lordship.
You also will kindly come to verse 19, my lord.
Yeah.
That is the order dated 26 December 2016. Wherein I was
What is your prayer?
but I was transferred in the year 2016. But that transfer could not be implemented as because other affected persons challenged the same. They got an interim order by the Annexure 3 Series page 21. So since I could not join my transport page, that's why I reported my joining before the government as page 23. Page 23, I reported my joining before the government, but that joining was not accepted. But they modified the order of transfer after 2 years, that is in the year 2019 or page 22. So, 2019, they modified my order of transfer, improved the order, and they gave me the fresh posting. And thereafter, I joined there and retired in the year 2023.
Yes.
Whatever that period of break, that is from 2016 to 2019, has not been regularized. It would have been treated as an extended joining time, including the provision of the service code. So, can you have a look at the.
You did not report for duty pursuant to transfer order.
I reported in the place of posting, there they did not accept my joining as because the order had been stayed by the lawyer tribunal.
Then you should have gone back to the same.
I reported it before the government. Government should have accepted the joining report as because they have accepted the joining report of some of the similarly placed persons. So they modified my order of transfer in the year 2019 in view of the order passed by the tribunal. So there is a break of 2016.
No, but you have not worked during that period at all.
They should have that, but they have accepted.
How?
They should have accepted my joining at the government.
Where is your letter? Saying I am not able to work here or there. You will work somewhere.
Page 23.
Page 23. Okay. This was given when?
2017.
Transfer was dated.
Transfer dated that is 26 December 2016, and the interim order was passed by the tribunal on 13th 2016. It is the and you also kindly,
Where is the proof that you have given this letter to?
they have modified themselves the order of transfer.
That's all right. Where is the proof that you have served this copy on the concerned officer?
No, my lord, you also, I don't have proof, my lord, but they say they have modified themselves after 2 years, my lord. So that
All right, they will let them modify. But that does not mean you can remain away and you can get the benefit.
no, my lord, that's why I want to notice me should they
No.
come up with the response, my lord.
None.
And because you are also my
Otherwise, the state exchequer will be poor, it becomes poorer because once we count that service, to that extent, it will be addition to your terminal benefit.
complete break in my service, I will not get to pension, my lord.
Now what can be? Why did you remain outside?
Then I didn't remain, I reported, my lord, and they have them, you also kindly come to page 24. They themselves have modified the order, knowing it very well, because there was no objection to modify the order of transfer, you also.
No, any modification took place. Why did you keep away from duty?
They did not accept my joining, my lord.
Where have you been accept my joining?
You know, that's stated, my lord.
Otherwise, firstly, remaining away without reporting for duty itself is a misconduct. It's a ground for dismissal.
Then I reported, my lord. I also when it came to page 8, paragraph 7, I have stated that.
Page 8.
Paragraph 7, my lord.
No, in petition you have stated wisely. You are a wise lawyer. But where is his representation, your client's representation?
That is, my lord, page 23, my lord.
23, what is that you have said?
I have said that in pursuance to government notification number such and such dated 26/12/2016, communicated High Office of the order number such and such of bearing the second institutional position, I explained to Diet Triagon and joined into that principal of Diet Triagon on 3/1/2017. But the in-charge principal says Jugal Kishore Mishra did not hand over the charges of the office to me on the plea that the said order is paid by the OIG, so I had to return issue
Emergent notice. Let us see. Yeah.
the governor said,
88 works of purpose. Not a good case. Yes. I don't know. Sanctioning of increments.
Increments are not
Any representation is given.
increments are not given.
Then you give representation
Yes.
because you are seeking mandamus.
Yes.
All right. The petitioner has the scripted
Instead of 23, let them place. So I find place the reputation.
No, this here they have given where is the consideration? It's 23 means you should have done all these things before that. Mr. Monti, 23 means 2 years are over because your officials slept over it.
Subsequently, order has been passed. So when the next page,
Saying
let's try to it. If they recorded my name for registered, there is no objection to the government if I will register in service. So I registered in service and unlisted does it create 29 unlisted age. Registered in service. And there are increments that are getting living on the.
now, where is the rejection of the representation for grant of you have said that hold disciplinary inquiry of this level. You hold the inquiry and hang him to the nearest tree. But how you can hold back the increments that are statutorily agreed to an employee? Short grievance for petitioner is reflected in the prayer column as a first one. Learned counsel for the petitioners draws attention of the court to the client's representation dated 14 to 2023. Wherein he has requested for sanctioning of the increment. First one. He also points out that no decision having been taken on the same amount. This court is eminently warranted, eminently EMI, not I, whenever I was doing everything. Whenever I say eminently, you will write eminently. Whenever I say eminently, you write eminently. Different words they are eminently warranted. First, lovely DG, Mr. Mohanty, accepting notice for the notice, very simple step. You would instruct the client to look into the grievance of the petitioner as if he hears the subject representation in a time-bound way and in accordance with law. Should all contentions be resolved, first, with this proposal, counsel for the petitioner is first, in the above circumstances, petition is full of time for comparison techniques, which would include communicating the decision taken on the subject representation to the petitioner. First topic. Next, open to solicit the information and time periods for 8 weeks. That is 8 weeks. Within 8 weeks, he should inform you also. Right. No.
English item type.
My lord, petition the widow doctor, my lord, claiming for family pension that has been rejected by Annexure 6, my lord.
On what will?
On the ground that petitioner became a widow after the death of the my lord.
This matter you had argued before me earlier. Not argued.
No.
Similar matter was there, some other. On the ground that you became widow after the marriage.
After the death of.
After that, what was the property you have taken of the husband, deceased husband? Suppose you are married in Birla's family, Tata's family. Okay, then some misfortune happens. Can you seek compassionate appointment on that? No. That is for where the breadwinner dies and the dependents are starving. For those, the provision is made. What is the asset and other things holding? You are holding. That is rejected. Where is the rejection order?
That is not coming. Next 6 to 31.
Page 31.
Page 35 is the ground. Page 35.
One second. Go to that. And that's 6. No, kindly see para 3. Come to page 32. Family pension was given to mother. Wife.
Minor.
Huh.
Thereafter, in 2007, mother died. Then became 96 widow.
No, that's unfortunate that you became a widow. That's another thing. But what is the property holding of yours? How can that be given? That is not a guarantee for everybody. No.
No, after that, at time of the minor son was
Minor son. Now what your son is doing? What your son is doing? Go against the son. Go against the others.
the original digestion ground is the one taken ground that the diet of father the was after.
He died in 1986.
That is already.
Huh? 86, 20 February, April 1986. No,
Of money, rejected on 325. It's a
Page 25.
no, 325 is rejected. The max 25 rejection.
20.
Remains that.
20.
And the similarity notice.
No. Son or unmarried daughter for life subject to the following conditions. Unmarried daughter, whether it would include widow or the daughter also.
My
How?
as my love page 24 my. In case of widow daughter also eligible. That is a
24.
my love page 24. Para in my love. In the case of widow, divorce, disability widow, disability divorce daughter, given after exchange of 25 years in their remarriage or death, whichever is subject of
Now, how many children you have got?
what?
One child. What is he doing? What is he doing?
Educated, not unemployed, not employed.
Not employed. Then he also will file application for maintenance.
Okay.
When there is a son, like what is the educational qualification of the son? So where are the material particulars in service law?
Sorry, the petition being an Uddolata claimants.
Without daughter. No, I am asking you, what is your daughter doing? Your client's daughter, son doing? How many sons? What is the property holding? What is the bank balance? What are the shareholding? Where have you mentioned?
I have not mentioned. Also, on the rejection, they have not any ground. Ground, only ground that
You state
that
everything. Then now I can consider petitioner to furnish the information as to how many children she has begotten and what they are doing. And also, what all the property her husband had at the time of his death. First, registry to send a copy of this order to the jurisdictional deputy commissioner. Who is that deputy commissioner? Which district? Registry should send a copy of the writ petition along with this order to the deputy commissioner, Denkanad district, for furnishing necessary. Which district?
Denkanad district.
Denkanad district.
Superintendent SP.
District Commissioner, no deputy commissioner, district collector. District collector of Denkanad district. Denkanad district. Issue notice. The DG accepts notice pursuant. All right. If it is false, then I will direct the arrest and detention of your client. Yes. Item 6. Yes. Can you change the dates and other things? Just give.
Unanswered statement is there in both the applications.
It's similar to
They rely upon certain decisions. In light of that decision, that
you consider. Same or. Next also say sub item. Okay.
Item 7.
Page 17. 78. What is your prayer?
But my prayer is to suggest it was this order issued by the opposite partner number 1, that is the Government of Police Skill Development and Technical Education Department. But I have given representation. This is the second round litigation of my partner. The first petition I was directed to file a representation, and the second will be considered by the opposite partner number 1.
That is rejected.
That is rejected.
Where is that?
Page 78.
What is 78?
70.
On what group it is rejected?
Lord, they have mainly rejected on 2 grounds. That this the petitioner's prayer cannot be accepted at this point of time because it's no more in work, and the strata to which the petitioner is seeking to be transferred, my lord, is now abolished.
What can?
Lord, but my lord, what my humble submission is, Lord, if your lordship will see that this is not, if your lordship will see in my page 40, lordship may kindly come of page 40.
40.
Yes. But this was the rule, the erstwhile rule under which my appointment was made.
Yes.
So that starts from page 38 to 14.
Yes.
And you lots may kindly see at page 40, it will be at C, clause C. It was the post carrying the training officer or foreman.
Right.
But I was a training officer admittedly, and my appointment letter was that.
Post to which you are seeking promotion.
Yes.
That is abolished.
Lord, I am coming. Yes, Lord, I abolished, but Lord, I could not have been promoted to that post which I was promoted because that I was not having the requisite qualification to be promoted to that post. However, the government will not sent me option either to exercise it or to reject it. People also will directly, I am just, people also may come to page 15.
Yeah.
50. I'll just play the sequence of events mode, then I'll not place my case mode.
Now, the question is, I have also practiced on the service law side. Therefore, I can visualize all the things. So I do not need fights because I will speak with my opinion. If the opinion becomes very strong and it becomes difficult for the board members to convince me to the contrary. That's the reason I do not read the papers. Okay, I confess that. The question is, Apex Court say, is where the post is abolished, question of promoting will not arise at all.
But that rule was abolished. Rule was repealed. A new rule came into force.
That came in 2013.
No, new 2024. 2013 rule, I was governed under that rule when I.
That is repeat.
That is repeat.
Under 2024 rules, are there any posts?
Yes.
Where
There
are
are posts. Page 15. We lost my kind. Page 15. 5G. On 23rd of February 2024, the opposite party number 2 issued an email to me saying,
No, I'm asking you.
yes, sir.
Where are the posts to which you are seeking the promotion?
The post of principal.
Yes. Post of principal.
Yes, principal in ITI college.
That post is there.
That post is there. Now what they are saying, since you have been given a post of lecturer in government polytechnic college, you cannot be transferred to the ITI college because these are now two different cadres.
Yeah.
Now at the time of joining, this was both these cadres were in one under one group. That is
And subsequently they were paid.
on the date. What has happened?
On which date they were paid?
Yes, just
Answer the question.
27th of February 2024.
27 to 2020.
Yes.
And option was given.
Option was given on 23rd of February 2024.
You opted for a stream. You opted for a stream which did not provide for promotion.
Yes. No,
Then how can
I was given an option whether to exercise that option, and if I want to change that, I was given 7 days time.
Correct.
Now why these dates are important? Because that option was given to me on 23rd of February 2024. That page 50 I just showed it to you. 23rd of February 2024.
Yes.
And I was asked to give my option within half an hour.
Within half an hour.
Half an hour.
You gave option.
I gave option.
You should not have given option.
Madam, yes. I should not have given option.
Yeah.
But he said that if I do not give option, then I'll forfeit all my promotional activities.
Where is that?
Page 15.
150.
Yes, 50.
50. Go to 50. Where is that? Where he written?
Yes, sir. 50 undertaking to as a lecturer on promotion in government polytechnics. That was the subject. It was issued by OP number 2 to me and all other training officers. But they said that, sir, madam, please find attachment and forward the same with your signature to the below mentioned email ID directly to SD&T department within 6 p.m. Now you also may kindly see that at the front at the
That's all right.
and then you'll also may kindly see the undertaking they have already enclosed there.
Where is that?
That will one attachment.
I willingly give my undertaking, join in the lecturer on promotion in government polytechnic engineering schools and will not make any further demand to join as trainer in ITI.
Yes, because
So
that,
given an undertaking.
that was undertaking that was attached on the page 15.
But you have signed also.
But I am signed.
Huh.
Not 10% this will at page 50, the office order was issued. And office order said but that I was given the appointment to the government polytechnic college a lecturer as page 53. Page 53.
As per your option.
Yes, sir.
Yeah.
And then page 54, my lord. There they say as one-time measure, following the notification and bifurcation of Odisha Technical Education Training Service Rules 1985, the person who are promoted by this notification are allowed a one-time choice to exercise their option to either accept the promotion or continue as such in their present cadre. My lord, what to do? Page 54.
Yes, I have read that.
Yes, sir. Now this option, my lord, I could have exercised within 7 days from the date of 27th of February 2024.
This is 27 February 2024.
2024. But
Yes.
you will also then come to page 56. On the very same day, Lord, the very same day,
Yes.
they issued another list where those counterparts of mine, they were promoted as principal of ITI colleges. And on the very same day, page 59, 27th of February 2024, they formulated separate cadre for both these two colleges. The formulation of separate cadre rules for the teaching faculties of government polytechnics and government ITIs by way of restructuring of Odisha Technical Education and Training Service Rule 19.
That option was given to you. What did you do with that option?
Well, I was given 7 days of time, but on the date of the very same notification, the cadre was changed.
What did you do with
But
it?
I immediately protested.
You
Because I was given. No, that was the if you also will see the first expedition, page 71. That was the opposite partner was directed to consider this representation. Page 71. Not I may not again before that I have given undertaking for
Kindly come to hence the above reason I was confused and took decision not to forego the promotion and next promotion might not be given and my seniority may hamper. That is why I joined a lecturer at Government Polytechnics on 27 to 2024. And also I had worked in government and so before giving promotion to lecture in government due to long exposure. I've got a lot of experience.
Subject is interesting for transfer and it's a principal in government items.
Send me back. Once option given, how to send you back? Apex Court say, once option is given, it cannot be withdrawn.
But the option also was attached with a discretion.
No, it is, you should not review on the option.
Lord, if you also I'll understand. One at 5:30 p.m. one government officer is the office is sending you an email
Correct.
asking the person
Give the option. You should have
otherwise
you should have said you are not launching any satellite. Give me 2 more days, 3 more days. I'll consult my wife, my spouse.
at 5:30 p.m. and they're
Correct.
asking you
You should have said it is not possible. I am not Aristotle to think everything within half an hour. But you have exercised the option.
but that exercise also carries 7 days extra time to change my decision.
But when did you change?
Because they did that promotion to me as a lecturer in government polytechnic college. On the very same day they changed the cadre rules. So therefore, even if my that this representation was given after 1 month, but that by also
Accept notice just to file up on it. Take note, please. Yes. Number 10. Once you have given option, Apex Court said in page option cannot be withdrawn. Yes. You should have protested. You have given half an hour. Is it that you are going to launch any satellite? You should have asked them. Then instead of that, you signed everything and you gave. And now you say I was confused. Where is the confusion? Yes. Item 8? No. I don't. This is explain it's being other elements we get. It is promotion. Promotion. Under annex 3, level 4 to level 5. Mine. No. From level 5 B to level 4. What? That is at annex 3, page 26. This is the office order number dated 18/10/22 in pursuant to the memo dated 10/11/10/21. The district education officer. Now what happened? Now he has been reported. His name found place at serial number 6 in the promotion order. This was 18/10/2021. Mine. Now why? And he has been allowed for more than 4 years. Huh? No, that's not. Why are you being reverted now? No reason has been assigned. No, the promotion was granted on the basis of craft seniority. The district level promotion committee duly constituted, and promotion has been given, and that has been given. What is the reason? What the reason? No reason has been mentioned. That is under annex 4, page 20. Simply they have written in pursuant to the office order number dated 10/25 of the district education officer Jagatsinghpur and as per the approval of the collector and district magistrate.
I collected and received my state has no jurisdiction. It is only the competent authority is the director of elementary education.
But this was in February.
Mine.
Then what happened?
Then I have represented the authorities and remain on leave due to my health issues.
Issue emergency police. If that order has not been posted to the which order, well, this improved order has been passed. That the constitutional officer number 10 to 2025. That is not changed. On the basis of that order,
But this has been communicated this way.
and the promotion order is subject to conditional, and the promotion is subject to finalization WPC and also for the application to the travel. Whether WPC was decided. That is what happened to that WPC? I have no knowledge. Then what research you do? How are you going to prepare the petition? I have to take instruction. You have already prepared the petition.
He has been allowed for the last 4 years.
You have said that.
Twice you have said mine. And rule says after approval of the director.
All right. That was subject to outcome of a writ petition.
Mine. Your clause.
That you have not said anything. Petitioner to state as to what happened to WPC. Who did that? WPC is not there. Then you only state that because he may not be a party there. You take notice and say what happened. The AC to take notice for all. Yes. No, because you have not made any research as to what happened to that writ petition.
But my lord, the petition number has not been.
You should have asked him. You have mentioned this writ petition. Which is that writ petition? Please give me. I want to examine that one. You have not right. This is February.
No. In the 2021,
Huh?
the writ petition number with my lord.
When did you find that?
21.
No, not that. You have filed this writ petition against February order.
Mine.
How many months have lapsed?
Near about 6 months.
Definitely. Issue emergency. Both on petitions and input things in application of ASC classmates. Yeah. Item 9. Other 9. At least 9. Yes. If we put a retired assistant teacher, while the president of finished, we allow the petition in the retired assistant teacher, while the retired teacher, grant pension matters below. Some matters we have nations. Yeah, but it is yes, yes, is all of this? Yes, but that's my fault. All this matter along with the number. Give that. Double one, give that. Yes, next. Right now also same. Item 10. It may be your yes. Here, after 6 years of retirement of the present petitioner, on the basis of unless excess payment made in the year 1983 my law by way of wrong petition, an order of refixation has been passed and direction for excess payment has been made my law. Then order is dated 12/6. 12/6/2025, 10/24 my lord. Issue is pay of the order in terms of application number 76 of in the lake of Traffic Mercy. Next page. Item 11. Related to revised scale of pay. Similar matters already issued this message. Impure model is not going issue to the history of this matter along with the number 2. That's right. 23361. Yes. On item 7. Item page. Not the page. Number 6. Not like any step. The district education officer letter minor. Annexure 4 minor. What is that letter? Letter annexure 4 minor. Annexure 4. Page 19.
In view of the above factors, you are requested to
for the suspension.
yes, sir.
Whom?
The headmaster of the attorney of the attorney Satrani Vidyapit.
We should be kept under suspension.
Yes, ma'am.
Who are you?
I am the informant one.
Informant.
My lord.
How you are concerned with this? You are informed and leave it to them. They will take this.
My lord, my daughter. Kindly, your offense, my lord, heinous of 126 to 75 and 351 to and 10 approximate.
How are you related to the child?
My child, my lord, kindly.
Who are you?
I am the victim, father, my
Victim's father.
yes.
Why you have not placed him under suspension? There is a recommendation already.
The recommendation by the hospital, the management, the education seems to
Correct.
the direction given by the DO, my lord.
Your DO has given the order.
Yes, madam.
Then if a DO does not enforce it, where he should go?
I am taking the order and issued on the 31st of July to trust.
Emergent notice for this, the DAC accepts notice for the OPs. Emergent notice 6.
He has to go notice.
Yes.
In the president of the
First. All this matter immediately after service is effective on OP6. Off. Next.
Item 13.
They have rejected it now. Saying
saying that mind I am an SC handicapped candidate. There is a determination of the government that if in the district no general candidates are available, then SC candidates can be filled up. This is the resolution of government. And the collector is there is the order of director of paper. Opposite party number 3. That in vacant general post, SC under candidates can be filled up.
yes, ST candidates can fill up the vacancies of double candidates if such candidates are not available.
In addition to and five, basic one annexure 5, which is the order of director. Government is higher authority than director. So government order cannot be superseded by director. Collector is following.
No, there is no vacancy. The vacancy is the
No, my lord, vacancy.
you have to pay 45.
But there are 139 posts and only 54 candidates have been given appointment.
No, why is the deputy collector? The collector will say falsely, no vacancies available. He knows that you will come. Huh?
It's saying no vacancy for SC post.
Not for general merit candidates.
General
You should be accommodated in general merit candidate because the order says that way. You take notice for them. Yes, yes, notice first. Yes.
Item 14.
Yes,
Alexa is preparation given. The benefits of lecture, group-based scale, reader scale, on the commission and government effect, Alice lectures placement rule. Similarly, placed in locality in different
what you have done in that matter? So, any matter is covered by judgment. You get.
Alice, 8 is very good.
In the light of this, they have to consider.
Right.
Brother. In the light of this judgment, you consider that. But the short grievance of the petitioner is as to non-consideration of his representation dated 29/8/2025, wherein she has sought for extension of benefits of lecturer group pay scale with effect from 2010 and reader state scale from 2020 in accordance with the placement order of 2014. First, the said letter is that the rate and it is issued to the Secretary, Higher Education Department, Government of Orissa. First. Next one. NDBC. Public counsel appearing for the petitioner vehemently argues that the matter is no longer rescinding law. In view of the decision of this court in WPC 2062 of 2024 between Loknath Behera versus State of Odisha, decided on 13/8/2025. And therefore, there is no impediment for favorably considering the subject for consideration. First, that having not been done, indulgence of late court is eminently warranted of argues the counsel. First, learned the ASC of initially resisting the petition now fairly agrees to instruct the OP number 2. Two. One. OP number 1. How many Orissa states are here in this state? How many Orissa? State of Orissa is 1, state of Orissa is 2. You want to divide the state? Only one state of Orissa. Then Secretary, Department of Science. That way it should be. OP number 1. What is it? I think these two OP number 1. To look into the grievance of the petitioner, as has been held in the subject of presentation in the light of Loknath Behera Sutra, if all contentions are kept out. First of all, peace property consent for the petitioner is legally next in our circumstances. 8 weeks. May solicit any information. Okay. Can we retain this copy? Retain this copy. Yes. Jump 50. Praying for tomorrow. Today is not good day. Shukra the good. What is this matter about? Just I will assist you. You don't kindly give over fatigue. No, kindly take a new file to say doctor. No, just start. I will give you. Is it RSA? RFA. What is this matter? Just turn the pages. Go to first page. Is it criminal appeal? No, it's a civil matter. Is it RSA? No. What is this matter? We'll give you 15 minutes. You just go through and you have to come and argue. Okay? Now, pass. Read the file. And return court file also. Then we will go with our file. Yes.
Item 16?
Yes. You only have to argue now. We have given the file to you. Okay? Sit down and read. Yes. Mr. Veda. What is this matter to that?
I am the petitioner is working way.
What is your representation in it?
Representation to the opposite part 1 and 2.
What about
my engagement and reappointment?
for your reappointment? You are earlier working.
Yes.
When during what period you were?
I'm since 2015 working as a lab assistant in the Jawaharlal Nehru University.
You were working as
Lab assistant. Lab attendant under MS Vigilance with stable executive.
lab assistant.
Yes.
From what period to what period?
Since 2015 to 2025.
There is no structure of telling the date in this quarter. Available means you are the person who takes information from your client. How judge will come and sit beside you when your client gives information to you? You can't expect that the judge should come and sit beside you and whisper into your ears, tell the date, ask him the date. 2015. April 2015 to
from 2025, madam.
10 years you were.
Yes. When I come back to my native town, Rahulkela, there is some difficulty and I was arrested.
You were arrested.
Yes.
What took place?
In a criminal case.
In a criminal case.
Yes.
What happened to that?
That is pending, my lord. Charge sheet is submitted.
But then how can you know?
When they return back to the jail,
Case relating to what?
you know,
Criminal case relates to what?
Lord, I am showing document, my lord.
GR case number 806 of 2025.
Yes, yes.
What is that? GR case means what?
Government record case means the case is registered on the police station. And PS case was held there on GR case is
Under which section?
420.
420. What did you do?
Some
420 is a cheating.
cheating, yes.
Yes. How the cheat should be entertained by the government? Tomorrow if you cheat the government?
No, my lord. When separate person, my lord, is complain the police station, and I am taking some money
You have not returned.
to the that client, my lord, which is not written. That's why it's filed there.
You were arrested for how long you were in the custody?
Yes, I am so.
And on 22/4/25 you were arrested.
Yes, your lord. I released on bail on also 18/7/2025.
22/4 to
18/7/25.
three months sir, for 420. What kind of bail codes? The allegation is 420. He was in jail custody for 3 months. Ununderstandable. And it's a matter between about two private individuals. Why you want to send him to the whatever happens to the criminal court, then you can take the decision. Already he has suffered now.
My lords, the opposite party has it since Jawaharlal JNU Delhi. Not my lord. I don't have any.
20. Yes, sir. 3 months he was in custody.
My lord.
But he was in judicial custody, which I do not know which magistrates will function like that.
Then
You consider the representation.
No, my lords, I will not appear for the opposite party.
You will not appear for this issue
This
emergency.
is JNU New Delhi.
Issue emergency. If there is a private litigation,
My lord.
that ground how a person can be.
But the rule says
Of course.
somebody 40 beyond
No, that is
40. It can be
Suspension.
suspend. Yes.
Speech.
No.
Correct. You take emergency.
yes.
Yeah.
17 years ago, the petitioner made an allegation against October number 5, my lord, who has got appointment as assistant teacher under rehabilitation assistance with producing a grade certificate. Motion may kindly see page 32 and page 25.
Page certificate relating to
BEd certificate. BEd, my lord. Page 25, here.
Who are you?
No, the petitioner is the president of the alumni of that school, alumni association. Already he was placed under suspension, open number 5. No inquiry has been done and this serious allegation has been made for which he has also represented before the opening of one, the School and Mass Education Department. And NHS 17. So he has page number 44. I pray, my lords, let them take a decision and conduct an inquiry against open number 5 because there are multiple
in the representation. Between the 2 weeks between by April 17. In 17, submitting to the Commission, 20 Department of Schools and Responsible Education. government approach or taking action against whom?
45.
Would be number one. First. On the ground that he has the next perfect change and continuing that. And fabricated several accounts. Also, learned consent for the petitioner is that when that's a representation of the authority to whom it was addressed should take follow the same in accordance with mind with it reasonable. This having not been done, this court should issue an appropriate action in this regard. Personally. Next person. Learned AG appearing for petitioners on request in all fairness submits that. He would instruct OP number 1. OP number 1 to look into the grievance of the petitioner as has been heard in the subject representation in accordance with law, and for that purpose some reasonable time be granted. First.
My lord, in fact, he was put on the suspension. It was inquired into, and he submitted on certificate. That is the state. It is not that it was not considered.
No, thereafter what he has done?
Action should be taken. Those two.
If an inquiry is exonerated, well and good. But you have to pass final order on the inquiry, saying that in the inquiry he has emerged victorious. And you can give Nobel Prize also. No issue. But you can't keep it pending as such.
It should be done by the EU.
DO. All right. EU. First up. You just instruct him to take a call in the mail. And inform the result of that also. So that he will not come here to the court. Next part. In the above circumstances, petition is disposed of. Directing the OP number.
Where do you go party?
Address to Divan,
OP number.
1. DM is OP3 and 1 is secretary is to
OP numbers 1, 2, and 3. To consider or cause to be considered the subject representation within a period of 8 weeks, and to inform results thereof to the petitioner.
OP number 3, your lordship.
OP number 3.
Man.
OP number 3. Therefore, I said consider or cause to be considered. Whoever. All conditions. Okay. No. Next. Okay.
Case where the petitioner for calculating the date of declaration is rejected errors. The petitioner is claiming accuracy of date of declaration based on the order passed by the that is Hon'Ble Court, which has been confirmed by the Hon'Ble Act.
Yes, brother. There are 2 judgments now. You take notice and say something.
Neither.
There are subsequent. Matter lies in a narrow compass, and largely it appears to be no longer resting ground. First, for immediate application.
I take notice to open the part number 2 and 3.
So, emergent notice to be going.
Yes, sir. Great.
Next.
Question 19.
The petitioner working as a primary school teacher in the government primary school manner. Challenge Annex 1, whereby the OP number 2 has taken a decision to implement one unified automation system in respect to all teachers.
Yeah.
On this ground manner, so without providing adequate facility, in terms of facility to implement the same cannot be implemented by the teacher, the petitioner. On the ground, in order to implement that unified automation system, the teacher must have a smartphone or Android phone having mobile data along with the internet facility. Because all the attendance and teachers' attendance, student attendance, as well as the leave application is to be issued under the new scheme. Now, without giving any facility, mobile phone or mobile data, now state they are imposing to implement the scheme. Now, as a show an issue to the headmaster, So why the teacher has not been issued the implement scheme? That is out of seminar.
No, you tell it. You are not furnished any.
Yes, I have repeated the same.
Yes, then till the action is taken, you wait. Suppose the object is to see that everybody will be at the place. Suppose 10:30, I have to come to court.
Yes.
I will come to court at 12:30.
No, there is attendance.
Similarly, the children should not suffer. The other staff should not suffer.
Yes.
Everybody should be on the chair at the right time.
Yes. That is happening.
We do not know. If that was happening, why government will issue such policy decision?
Because this decision is taken that which require
Anyway, your notice is issued to you.
No, notice issued and answer based on the.
Yes, you send your reply to them. Why are you here?
I am in representation without giving the provide card.
You tell them. You said that.
Now
They have given show cause. You show cause.
So not to me, to the headmaster.
Yes.
Now the headmaster is compelling you implement this scheme.
You tell the show cause. Who has issued show cause?
That the BU woman.
You answer BU.
Mine. I will also make permission.
Do you want to withdraw? Should I dismiss the petition?
No, I will.
Petitioner, having argued the matter, seeks leave of the court to withdraw the petition, with liberty to send a reply to the show cause notice dated
matter 20th August
2025. A copy whereof
and accept
that an excerpt by. First, liberty having been granted, petition is disposed of.
Both the matter. Provide
Both. Registry to send a copy of this order to all the witnesses by speed post immediately.
Similar, itself had portrayed the case of land 20 years back. Now the Operation Part 2 and 3, that is video authority want to implement the town's plan scheme. By virtue of which they are taking out this passage and parking instead of the pits. If it's the raise objection or an honest plan which is pending before the appeal about 2 months.
Annexure 1. They are taking your property by acquisition.
Not acquisition, implementing a town plan scheme on an annexure 2 months.
Your private land is being taken.
If they are the land acquisition, that is the different process.
Right.
That's not going.
Now you have given representation. Saying
that the you have purchased 20 years back.
In the representation, what you have said, what you told them.
Told them, I have using that 20 years back, I have purchased that. That is a passage and parking set. I have used that part of land. And the land was purchased in the name of his wife, which he has died.
He has died. After death, what you did? Rituals and other things that apart.
What are there?
Huh? No, what is that represent? What is your prayer in the representation?
They objected to that scheme. That is the simple thing.
That should be considered. You will be happy with consideration.
Not the similar matter.
Huh?
Similar matter, but on our answer, the coordinate plan to this directed to consider the objection and for that opportunity of hearing should be given to the.
Why you want to take the land?
My lord, so this is VTA, development authority, but right, as it seems, my lords, there was a demarcation this is not affected in lordship will direct VTA authorities
who appears for VDA.
Mr. Mahapatra and senior advocate.
Bring Mahapatra, Mr. Mahapatra.
I will submit to you on.
In some copy, issue emergent notice, AGA for 1.
156. 156.
Municipal Commissioner, na?
No. 156.
156. AGA appears for 156. Emergent notice. Move it to the petitioner to serve copy of the petition on the panel consent usually appears for other block, other 220. In addition to taking visual steps, I petitioner has good applications application by supported by application. He applies that without any procedure of law, his property will be forcibly taken, which is which would be violating of fifth and substance of Article 3 of the Constitution of India, broadly interpreted state of emergency way, since there is the possible threat of disposition or demolition or encroachment in the private personal areas. Certain parties are directed to its status. Into next day. Yes. Next. 21. Yes.
Petitioner joined as referred by the collector Kalandi in the year 1992. 92 in the district of Kalandi.
Yeah.
Lordship owns to annexure 3 as headmaster.
As headmaster.
I want to be posted as headmaster as per the letter dated 29th March 2016 under annexure 2.
You read your first prayer.
First prayer, the opposite party number 4 collector from district magistrate Holandi shall not be directed to transfer.
Shall not be directed. Well, I not directed.
No, why? The person is that prayer is starting with why.
Why?
Why?
Where is that one?
The last, fourth last way. Why?
So we should ask him why he should not be directed to transfer. He should be transferred now.
Transferred to the ashram school because the petitioner joined as Sevak in ashram school. Ashram school comes under ST and SC development department. It's not a general school. It's for development of the scheduled tribe and scheduled caste poor children with residential facilities are there. Food for because there are large dropouts in Odisha. So these schools were created.
If your second prayer is granted, will you be happy?
Yes, I will be happy. But I lordship to bring to annexure 2. 1 minute, your lordship.
Annexure 2.
Annexure 2, your lordship. This is the letter issued by the government of Odisha, ST and SC Development Department, saying that I am directed to convey the sanction of Governor Odisha to the creation of 165 EGT headmaster posts in the ashram schools in ST and SC Development Department as per the details at Annexure A. In lieu of the abolition of equivalent number of posts of Sevak and Sevikas of the MCT cadre in Sevastram and the residential Sevastram establishment indicated against respective district in the statement enclosed herewith at Annexure B with the following terms and conditions. I will bring your lordship to part 6.
Read 6.
3 your lordship important, then I will come to 6. It will bring permission.
Yeah.
The Sevak and Sevikas having bid qualifications shall be promoted to the post of newly created headmaster under pay band of 9,300 rupees with grade pay of 4,200. All required and prescribed formalities including ORP Act will be adhered to while promoting the eligible Sevak and Sevikas to the post of TGT headmaster. These posts were created to lordship.
Now read 6.
Yes. Creation of 16 TGT posts in Assam School in ST SC Development Department as per the details of Annexure C has been kept in abeyance with in view of the interim orders. Hon'Ble OAT in OA numbers, there are so many OA numbers, 3 to 4 OA numbers until further orders of the Hon'Ble OAT Bhubaneswar is received. Yeah. And my school is not coming under that because Kalani district not coming under that. Navram district, that has been the list has been provided under page running page 22 year lordship.
This class 6 is not applicable to you?
No, because there are all weighty matters are pending where belongs to Navranpur district, page 22. It's mentioned list of school where operation Sevaka post of HM has been kept in abeyance in view of the OA cases. My school,
your school is not here.
No, I belongs to Kalandi district and Kalandi. Yeah, appointed in Kalandi and I am serving out also in Kalandi. They are transferring me to different schools, your lordship, general schools, not in ashram school in lieu of the.
We will direct them to consider your representation.
Yes.
All right.
Yes.
In the light of
Annexure 2, your lordship.
Annexure 2.
Yes. That will suffice.
Right. The short grievance of the petitioner is as to non-consideration of the representation dated
They have received on 22/7/2025 approximately.
22
July 2025.
25. A copy whereof
Annexure 5, non-request 29.
very he has requested for being accommodated as a
Headmaster, Master School.
of the school in question in the light of government the commissioner's letter dated 29/3/2000, order dated 29/3/2016. No, in the light of which is that order? This is only
Annexure 2, non-request 14 your lordship, that is 29 March 2016.
2016. A copy whereof is at annexure 2. First, a perusal of annexure 2 shows that some posts have been created and a duty is cast on the jurisdictional office to consider the candidature of petitioners, persons like petitioner, to the post of employment. First, learned counsel for the petitioner complains that despite representation, nothing having been done, this should come to the aid of petitioner who belongs to scheduled caste or scheduled tribe.
No, that's equals to general caste.
General category, but
Appointed as schools are ashram school, may repeat STM.
first. Next paragraph. Learned AG Mr. Behera draws the attention of the court to the observations in the said order which refers to some case in OA number 337 of 2016, etc., wherein the Central Administrative Tribunal, Orissa Administrative Tribunal, yes, OAT, appears to have made some order, interim orders, and therefore the subject policy is kept under suspended derivation. First, whatever that be, now he submits that he would instruct his client to look into the grievance of the petitioner as has been aired in the subject representation at annexure 2. Annexure 2.
Annexure 5 is the
Annexure 5. Annexure 5. In accordance with law and within a reasonable time. First, this is appreciable. Next paragraph. In the above circumstances, petition is of 8 weeks. Solicit information so and so. Result to be communicated. Now reports.
With the name of prayer to the Lord, he has to be appointed as a headmaster in ashram school. They
We have said, consider the representation. We can't allow the opposite party number 4 to connect to the OP number 4. Okay. Item 22.
Well, following upon added institution, the claim for salary for some period, that is from
58 to 94.
Well,
Salary is not paid.
not paid. Similarly,
94 means but 20 years, what were you doing?
well,
30 years.
I have made several applications I have made, and now in the meantime they have to extended the benefit 2024 to the similarly the school manager and it's a court.
Where is your representation?
And it's a 6 months.
The short grievance of the petitioner is as to non-consideration of his representation dated 10/7/2024, a copy whereof when set annexure is 6, wherein he has sought for release of they have sought for release of the arrears of salary
Well, it is.
that has accrued due during the period between 1/3/1988 and 1/6/1994.
It's 31st May.
Right?
1694 I am getting till 31st May 1994.
In 31st May
1994.
31/5/1994. First up. the counsel for the petitioner submits that to the similarly circumstanced other employee, the said benefit has been extended, whereas extended as per Annexure 4 and 5, Annexures 4 and 5, whereas a stepmotherly attitude is shown to his clients, and therefore this court should be remain in the next one.
This is for year 88. 94 GIA was given to them. They have never objected. And after retirement, now they come after 30 years, Lord's that your Lordship.
Learned AGA appearing further notice vehemently exposes the petition, saying that the court should not come to the aid of sleepy and tardy, said Jeremy Bentham. First of all, he also tells that the writ jurisdiction cannot be tackled after long delay, obviously evidentiary material not being available for decades. First of all, having so contended, now he agrees to instruct OP number 2, OP number 2, to look into the grievance of the petitioners, keeping in view all contentions that are taken up in the petition and that may be available to the officials as well. First, next paragraph. In the above circumstances, may solicit information, etc. Item 23.
Similar to minors are posted these all the cases on the 10th minus. 10th October.
Issue notice. All along with WB number. So,
and I am also
any private party.
Yes, madam.
Emergent notice 2. OP numbers 4 to 7. 4 to 3.
I have mentioned my other related similar matter I have mentioned in this order directed to all the matters listed.
Yes.
Given the order in the
Because all this matter, along with those matters, on 10th of
October. Okay.
In that date is already fixed.
My lord, in the earlier is my lord,
Then you have to fix a date here for this matter along with those. Okay.
Item 24. I hold up before your lordship. If there is a petitioner who is working as a principal in charge is challenging the transfer order dated 11/9/2025 on 2 grounds mainly due to MLA recommendation and only 8 months of service is left minor.
Have you been relieved now?
No, my lord. Now, as of filing date, I have not been relieved. The similar matter, my lord, have decided.
Well, let's hear on the public complaint. The MLA has recommended.
MLA has
Not that it is as per the act publishing MLA and people.
But the MLA said the public is
Public.
They can say that. That's all right. If he says, where is the inquiry? Suppose if some MLA does not like my face, he may say transfer it. People are saying, I am representative of the people.
Representatives, public representatives.
Oh, not
They have also some duty towards society.
It's the MLC, the teachers' constituency. Is he MLC from the teachers' constituency? Huh? Is he teachers' constituency?
MLA of the
MLA, all right. There are teachers' constituencies in your state also. I can understand if the member of legislative council representing the teachers' constituency making that application. How that MLA will see? I don't know that. Whether there is teachers' constituency in this state? No teachers' constituency. Okay.
My lord states on that day, my lord has also categorically observed and stated one thing. I was there in the hearing, my lord. He has stated political intervention in education department will be dealt. And my lord, only 8 months of retirement was also.
Retirement is within 2 years.
They cannot wait.
Yes, my lord. There is also government guidance are annexed to that. Similar matter.
Transfer orders then in public inquiry.
Every transfer is two English words.
Administrative.
Two English words. Public interest. Administrative exigency. Can create heaven with that. Hell also.
My lord, in absence of any malafide, why he will be transferred with.
No, even otherwise, I have seen guidelines. I have seen the guidelines which Mr. G pointed out other day very clearly. If they are in the verge of retirement, generally they should not be.
Normally they should not be.
Because my lord, that case
You give a representation.
My lord.
Till consideration takes place, we will not.
Similar matter.
That is all right. Now we have decided other matters also.
My lord, this may be
No, then we will dismiss the matter. You should go there. But you give representation. In the meanwhile, I will direct them to continue in the same place. I will let them take decision. If they take decision after 9 months, you need not worry whether this side or that side you are going to do that. If they take early in your favor, again you need not worry. Otherwise, you have come to before this court again. This is High Court, not this judge necessarily. Thank you.
My lord, may observe the
Short grievance of the petitioner is against the transfer order dated 11 September 2025, a copy whereof well set arranger. First, learned counsel for the petitioner very concisely attacks this order on 2 grounds. Namely, the order is actuated by the legal and factual mala fide in as much as it has been issued at the instance of the member of the Legislative Assembly of the state. And number 2, petitioner has got a short stint of service of about 9 months for attaining the age of superannuation. And therefore is entitled to protection under the transfer. First, he also tells the court that in similar matter, already this court has granted the reprieve and therefore the same should be extended to his client as well. First, next part. Learned AGA Mr. who appears, Mel Feher of hearing for the office opposes the petition, quoting Christian of the Apex Court, Varada Roberts, state of Karnataka, to the effect that all government servants are liable to be transferred, and when transferred, they simply obey the transfer orders. First, having so contained, now he agrees with the suggestion of this court that the petitioner should make an appropriate representation, and if one is made, the same shall be considered by the jurisdictional court in accordance with law. First, with this proposal, petitioner's counsel is also agreed, provided that he is given interim protection. First, next person. In the above circumstances, petition is disposed of. Semicolon. Petitioner is granted 1 week, 2 weeks for making the representation for recall of the transfer order or its modification.
Appeal to the director will
Appeal. Petitioner shall appeal instead of representation. The petition is disposed of, reserving liberty to the petitioner to file appeal before the director appeal number 2 within 10 days. And if one is filed, the same shall be considered on its intrinsic merits and in accordance with law. First, till such consideration takes place and result thereof is communicated, petitioner shall continue in the same school wherein he has been working before the issuance of the transfer.
All contentions get recognized in one single trend. Annexation law matter is really as per law and annexation 4 is the guidelines which are stated. I have law and guidelines of much grateful. Yes.
25. Well, item 25. This is regarding implementation of my lord's order. Contempt is filed. I contacted today morning that his prayer was to appoint him as principal in charge. And he has been appointed. But the drawing disbursing is kept with the sub-collector. For some days. Sub-collector is the drawing.
Drawing, survey.
Only 2 documents under file.
I'll file compliance affidavit. I have
Documents type. I'm saying we'll file compliance affidavit itself. What else is required? We'll record his submission is with liberty to move applications for revival for aggravated contempt. For aggravated contempt, if compliance is not kept. I will mention it in the advert. What is this called as contempt is?
my lord.
Yes. This contempt case alleges non-compliance of order dated 8/8/2025 passed by this court in the complainant's WPC number 22047 of 2020. Possibly. The operative portion of the order herein reads as that. With that. Page 8%. Page 8. 8 and 9. I will show it. Page 12. Page 12. And it's one. I'll put that if you need not say that. Okay. Next one. Learned counsel submits that the orders of the courts have to be scrupulously implemented by the parties thereto in general and by the government authorities in particular. Next part. Learned AGA Mr. Behera very fairly submits that already the substance of the order has been complied with by placing the petitioner in the office of principal in charge as was directed, and that only the emoluments need financial delegation of financial power, and that with regard to delegation of financial powers, the same shall be accomplished within 2 weeks.
Well, if it is kept with the management of the managing body, sub-collector. Because of some, I do not know exact reasons.
So he cannot keep it. He has no knowledge.
Yes,
But this is only one document. And again, sub-collector minutes, I joined there. The OP number 4 didn't hand over my charge, hand over the charge. I joined before the sub-collector. Sub-collector requested government might in this letter minutes to delegate financial power in my favor, Lord. 26/8/2009, that is considered. And thereafter will also there. Yes. He says that it will be done within 12 seconds. That's a candidate, person. In this connection, the sub-collector himself has addressed a letter dated 26/8/2025 to the Special Secretary to Government, Department of Air in Odisha.
which reads as that. Okay, this copy will be in there. It reads. Next. Keeping the assurance of the learned AG on behalf of the contemners, this contempt petition is dropped with liberty to the petitioner to seek its revival by moving an application. If compliance, as has been undertaken now, is not adhered to, first, ordered accordingly. To move application for reviving of this one. Okay, if they do not do that, then the action starts. Only one prayer, project time, the time you will call. No, 2 weeks. Within 2 weeks only. Otherwise, I will summon them here. Next.
Item 26.
Maybe.
Yes.
Rejection of my petition in person to direction of this honorable court. That's why I'm finishing government while without considering my grievance lordship, because there are two aspects lordship. I am a successful candidate lordship. I have been appointed since the 2011 in person their own notification lordship.
29/8/2011.
11. In fact, during Cambridge the application, lordship can see Annex 2, they had offered me lordship for an appointment, but it could not be acted upon because of pending the application before this honorable lordship. So
what happened to that petition?
Lordship disposed of with the direction lordship to absolve me, and they absolved me lordship recently, but without giving a Annex 3 lordship, they absolved me on 7/2/2023 for the direction of this honorable in a writ appeal lordship. In writ appeal lordship. This is directed to absolve me, and they absolved me Annex 3 page 36.
They have observed you now.
Lordship. But either they are giving me the regular post lordship or they are giving me benefits under the present ongoing lordship policy of the state government. They have given me appointment with a financial benefit, which was lordship existing in the 2011. And in case in 2011, I could have been absolved. After 6 years, I could have been regular in service, and lordship, I have to be lordship getting a regular pay. Or lordship, else lordship, if they are giving me appointment in the 2023, as per the policy lordship, my salary is entitled to around 25,000 lordship. But
Now, how much you are trying?
Lordship around 8,000 lordship, and in my employer the last 6 months also they are not giving me salary lordship. I am working.
They are not giving that salary.
No, that salary lordship.
Despite your engagement order date, it's away to 2020.
23 lordship. They are not giving that.
To take lordship, next 6 lordship. It's the option of this matter.
No, first time it is coming.
And it's 11/3/2025. Yes.
Whereas Honorable Court in the High Court of Orissa has passed order in WPC number 33643 of 2023 and dismissed the writ petition filed by the petitioner by the order dated so and so. That even though a prayer has been made to modify the order of appointment by offering regular service to the petitioner, but no order of appointment is enclosed to the writ petition. In view of the same, as prayer has been made in the writ petition cannot be entertained. Accordingly, the writ petition is dismissed. However, it is upon to the petitioner to approach the authorities seeking modification of the appointment order.
No, thereafter appeal was filed. Writ appeal was filed.
Prior to that, after that writ appeal, they absolved me because they did not give me salary as per the direction of the honorable court. I had approached this honorable court, and this honorable court said also because that pending there.
Now
they let them consult, then you come.
There was
My
the application.
lordship kindly see that's
For modification of appointment. It has tried to extend regular service benefits to effect from 23/2011. There was the modification now, therefore, there was the application dated 25/9/2024 of Sri Vinod Bihari Bag and went through the case records and found that the petitioner Vinod Bihari Bag has been selected for Shiksha with the BA
on a fixed monthly honorarium of rupees 3,500 pursuant to resolution dated 29/1/2011 of STSC. The Development Department of the Government of Orissa and issued engagement order by the office order number so dated 17/9/2012. But it didn't join as such in the year 2012. Hence, it forfeited the right to claim for engagement as teacher in PS category. Further, as per the Honorable High Court, A number 47, very appeal number 47 of 2014, he was again appointed as teacher by this office order number 7/2/2023 and posted at so school in the existing vacancy. He had joined as such on 9/2/2023 and continuing his service till date. In view of the above, there is no provision of regular service in the retrospective effect. The application of station must be back dated 25/9/2000 modification for extended citizenship to extend the grants and yes, no, right.
No, me.
Yes. In fact, Lordship, can I say my appointment, I had Lordship since 2011. And Lordship, in fact, Lordship, they did not give me appointment despite my eligibility. That's why I approached this Hon'Ble Court. And during pendency writ application, because Lordship, I am a person, Lordship, handicapped Lordship candidate, but they absorbed me in ACBC category, Lordship.
They absorbed when?
Lordship, in 2000, Lordship, that is 2012.
But you did not
because that post was not available with their Lordship. Because they have Lordship that ACBC post was not available with the, as per the advertisement. That's why I came up, Lordship.
They have given the appointment order and you are saying that post is not available.
No, in fact, Lordship, that was Lordship can confer the writ application. That was the entire ambiguity of the writ application, Lordship. They only to accommodate a person of their own choice, Lordship.
And you were given appointment order. With that appointment order, you should have asked that where I should sit.
But that time I have committed mistake, Lordship, by not joining Lordship. But Lordship, reason was Lordship that at that time relevant and case was pending before this Hon'Ble.
Why do you worry?
I came here for clarification, Lordship.
You should have simply withdrawn the case. And you have gone and reported for duty.
And the relevant and proper advice was not there, Lordship. No. But Lordship, reason there is a vacant regime, Lordship. There are no existing posts. That was also, Lordship.
Why? They have issued appointment order. And you are saying that there was no valid appointment. How will you sit over in appeal over the appointment order given to you?
But Lordship, my humble submission now, Lordship, don't want to join that issue, Lordship, because we have committed mistake at the relevant time. Lordship, can I state that if Lordship, I have been given an appointment in the year 2023 in pursuant to the advertisement, Lordship, 2011, then to stop with me, Lordship, to get the added benefit. Whether they will give the benefits as per the 2011 Lordship advertisement or Lordship the present existing policy of the state government. So Lordship, if they are getting the benefits as per the 2011 advertisement, I ought to have the regular Lordship. If they are giving the benefits under the existing policy, Lordship, my salary, at least my contractual salary will be high to 25,000, Lordship. This is now the only 2 months of prayer before, Lordship. So that.
Even your writ petition, earlier writ petition is dismissed.
No, Lordship. That writ petition, Lordship, on the ground of my application is pending before them, Lordship. That's why this one said, because the application pending there, go after dismiss the representation, you come, Lordship.
Kindly come to page 43.
Lordship, I have quoted, Lordship. In my writ application, I have quoted the order, Lordship.
No, page itself, the 43. Page 43, you come to 40.
Lordship.
Annexure 5. That order is reproduced by you.
Lordship.
Right. Even though a prayer has been made to modify the order of appointing by offering regular service to the petitioner, but no such order of appointment is enclosed to the writ petition.
That's why, Lordship, it was dismissed. Because the document was not annexed, Lordship, order of appointment. And Lordship directed to consult them, Lordship. Then I approached, after this refusal, I have approached the Lordship. That is not a Lordship merit that has not been dismissed, Lordship.
Approach the authority.
Lordship. I approached Lordship because, and then took a decision, then I have approached the Lordship. But
no, they have taken the decision.
The decision is Lordship, that is under challenge, Lordship. It has to be examined by Lordship. Because Lordship, kindly see my age and my Lordship, now I am working
with a lordship, RNM of lordship 8,000.
But it is your mistake.
Like,
When they had given offered the appoint engagement,
Lordship, had it plus my humble, just to play question to myself, Lordship, had it been I have been engaged in 2023 itself, and the same post under the state existing policy, Lordship, I would automatically get more than 25,000. Let's say, how do the same setup avoid?
you file your objection.
Lordship,
Issue number 10. Please. But even the whatever salary is not being paid, that you have to pay. Yes, that you cannot be paid.
I'm working.
My lord, the problem is that he is working, he should get, if he is working, for the period he has not been, it is objection that he is not getting salary. That he will get because he is working.
Yes.
If somebody is working, why he will be unpaid?
Why he should be not paid?
Not at all.
That you cannot extract work
No, without
payment. First, you have filed any application?
Lordship, in fact, Lordship, that I have a application.
No, there, prayer is something.
It can be confined on the area salary.
Confined to area salary, but
Lordship,
You pay him regular salary.
regular salary.
yes,
Issue emergent notice. That DGM is the G special counsel notice for the rupees. First, petitioner has moved an application in IN number so and so supported by affidavit, wherein he has sought for an interim direction to release the arrears of salary to personal. Learned counsel for the petitioner adds that even the current salary is not being paid, and therefore it has become difficult for his client to hold body and soul together in this costly case. Personal. Therefore, a direction be issued for releasing the arrears of salary and also the current salary. Learned AG, Mr. G vehemently opposes the application, contending that so far as arrears of salary is concerned, no direction can be issued at this stage. First, however, he adds that so far as current salary is concerned, he would instruct his instruct OP number. Correct, OP number 2 to release the current salary if petitioner is working. Yes, petitioner is working. First. Next paragraph. On the assurance of broadly agreeing with the submission of ETA, comma, this petition is disposed of. First now, OP number 2 to comply with the assurance given by the learned AG. Okay, forthwith. Yes, call this matter in the third week of October for reporting compliance. Right.
item 28.
Seniors have been promoted, my lord, including in consideration.
Juniors are promoted.
Yes, promoted, that's my juniors promoted. This is my, in the reduction list, that is annexation 7 page 38. No country file, as per particular.
I humbly submit, my lord, I will not cut for any time for finding counter. Because we have lordship have granted last time twice, man. So basing on records,
Yeah. If juniors are given promotion,
it should be, but
is it seniority come merit or merit come seniority?
lordship may kindly have a look to the election 13.
13?
13.
13.
Yes.
12, 13, the rejection order.
59.
12, 58, 59.
Yes.
That's 29.
59. Can I place this, man?
Yeah. This court deems it proper.
Yes. To dispose of the petition only on ground that the impugn rejection order that had
17/5/2023 under Annexure 12 doesn't reflect any ground on which representation of the petitioner has been rejected. It is needless to say that the authorities, while disposing of the representation, should have given reason for which influenced them, which way in their minds to come to such a conclusion. Accordingly, the court is of the considering view that the impugned rejection order is unsustainable in law and the same is liable to be suppressed. Accordingly, the impugned order at Annexure 12 dated 17/5/2023 is hereby suppressed. Further, the matter is remanded back to the opposite party number 3 to consider the matter appraised, keeping in view the order passed by the Orissa Administrative Tribunal within 6 weeks from the date of communication of the certified copy of the order by passing a speaking order, speaking and regent order. Decision so taken be communicated to the petitioner within 2 weeks. Pursuant to the order dated 6/7/2023 of the Honorable High Court, the claim of the petitioner is examined, which there and the following facts emerged. The petitioner duly selected by the Orissa
reported for duty after 3 years.
Yes. After 3 years, that is page number 60 of that sheet. It is there. Then during the year 2018, as many as 19 number of junior assistants have joined in different education directorate, duly selected by Orissa Subordinate Staff Selection Commission, and the recruitment to the post of junior assistants were on contractual basis as per Group C and D posts contractual appointment 2013. In terms of the said rule, a person being selected for appointment shall be on contractual basis for a period of 6 years from the initial date of joining, and on satisfactory completion of such tenure, one would be treated as regularly appointed. That while the above 19 number of junior assistants are so continuing on contractual basis, government in a GA and PG department by virtue of their notification dated 17/10/2022 repealed the above contractual appointment of 2013.
Sir, your client did not report about duty for 3 years.
No, but that is separate. They have suppressed some fact, my lord. The advertisement, Annexure 1, that was published inviting applications for regular appointment on 23/7/2013. Annexure 1.
23/7/2013
for regular appointment. By that time, the contractual appointment rule was not come into force, my lord. Then we are selected by the Staff Selection Commission for regular appointment.
Selected on
10/9/2015. And my position,
once selected and appointed.
only selection
Selected on
10/9/2015
as
for a regular appointment as junior assistant. For regular appointment. But instead of appointing on a regular basis, my lord, they offer appointment on contractual basis.
That was when?
On 16/10/2015.
What did you do with them?
That contractual term of appointment is challenged before the tribunal. The tribunal's order at page 34 and it's a 4, my lord.
What the tribunal said, you should have given the regular appointment.
Yes, ma'am. Consequently, the respondent authorities are directed to issue order of appointment on regular basis in terms of the advertisement. Issued by,
OTA number?
OA number,
OA number?
page number 34, my lord. 34 page.
OA number?
OA number 7C of 2018. Order dated 13/3/2018. That part they have suppressed in the order.
So, with effect from which date the tribunal asked
to modify the initial appointment order, my lord. The initial appointment order, that is on, it should be on 16/10/2015. The tribunal's reaction is to modify that order. That was the wrong offer of appointment contractual, that is wrong. The tribunal directed to modify that order. For that reason, they, in the gradation list, they placed me above all my lord. Counting that period from 2015.
So they issued a notification also dated 19/7/2017 to the effect that in terms of OA orders, your appointment should be treated as a regular appointment. Such a notification was issued. Yes, Mr. G, that because this order, yes, where is the reference to this order in the impugner?
In the impugner, it is not there.
That's a very important factor has been lost right off. This would make all the difference to the petition.
Yes.
Because there is an order by the Odisha Administrative Tribunal saying that his appointment should be treated as a regular appointment, as was advertised.
Nothing on the
Advertisement. And you have issued notification also. You have issued notification dated 19/7/2017, saying that all the shall be treated as regular appointees only, not contractual appointments.
Only the price for retrospective effect. That is what you must.
Yes, naturally, that has to be like that only. Because, but you did not report for duty.
No.
But then how you were
because the according contractual amendment.
That's all right. You should have the order is not to the effect that
Yes.
it should be with retrospective effect. Your appointment will be treated as a regular appointment.
Yes.
Where have you put in the service? Had you put in service as contractual employee, that service would have been treated as regular service.
Yes, but
You remained away.
claiming salary for that period.
No, given service. Service. Promotion is based upon service. Where is the service?
He joined on 30/8/2019.
Board director on 13/3/2018. The authority delayed it, man.
No.
Direction was made on 13th March 2018.
Correct. 13/8/2018, they have said that.
2018.
No, they only say, they did not say anything. It is not a contractual appointment, it's a regular appointment.
And they said that appointment should be treated as regular.
Right.
Modify that.
Modify that.
Modify that.
But it does not say, all these days when you are away, that should be notionally treated as a service. That has not been said.
That part has not been considered by the authority also.
Then we should have filed appeal on that.
But that,
Not authority. Where is the direction by the tribunal? Before the tribunal, battle lines were drawn up, whether they filed objections or not. Even there they did not file the objection. You should have got the order. When the judges dictate the order,
Yes,
sir, it is not like that. Kindly direct them to treat me as having put in the survey. From the day
why is my lord? Modify that order.
we modify that order, absolutely no issue,
Modify
but
that.
not with the benefit. We modify the order. We fully agree with that.
Modify
That date is kept in reach. The 19, at least 19/7/2017 also you did not report. You reported only more than 1 year after. That is 30 August 2000.
my lord. Since the wrong offer was made, I was rightly not accepting that wrong offer, my lord.
You are right in that. I fully agree with that. But what emerges from that? Even when you are not paid, you are not served, still your service should be entered in the service book. Still you should be made the payment.
No, I am not claiming payment. My lord. Not salary. I am not claiming salary. my lord.
No, what others did, who were given appointment, what others did. Those whom you are saying that they are equally placed, they had joined service.
In the next batch of, not in this way, I am not claiming in next batch also, next batch of recruitment, my lord. They have joined,
That was regular recruitment.
regular, no, contractual appointment.
Contractual.
Appointment.
But they became regular. They became regular after 6 years. They became regular.
They became regular from the date of initial appointment.
That is after putting in 6 years.
No. My lord, the next batch, the first batch, I was recruited in 2015, my lord. The next batch was recruited in 2018.
Yeah.
2018. In 2022, government made them regular with effect from the date of appointment in 2018.
Because they worked it.
Yes.
And you did not.
I didn't know what happened.
What can we do?
And I also see the they have in the federation list, they placed me above my lord. They placed me above the others, my lord.
They are placed above you.
No. My position was above the
Above those people.
Subsequent appointees. They are right in that way. But how can
But they are, no. Sir, now we have to say, you are seeking promotion. You are seeking promotion.
Promotion as well as seniority. Seniority put promotion.
No, the seniority is given to you.
Yes, they have placed me
Above the next batch. They have placed you above next batch.
No, my lord, on same batch. Above next batch, I also same batch.
Yeah.
They also place 40, my lord. Place 40. 40.
Serial number?
Junior assistants in the next batch. Junior assistants and sons. You see, serial number 1, 2, serial number 2, among junior assistants. Serial number 2, that's the government. Serial number 2 of the junior, amongst junior assistants.
Serial number 2, amongst junior assistant.
Subhash, they are promoted. We have promoted Subhash Chandra Nair. They have promoted serial number 4, 5, 6, and 7 of 2018 batch. I was elected in 2015 batch. The next batch, my lord, that is by that's the problem.
Who are promoted now?
Serial number 4, Tilochan Sahu. 5, Chandan Kumar Bhanji. 6, Konga Das. And 7, Suresh Chandra Buru.
Yeah, he is senior to them, Brother G.
Well,
He should be senior to them. Why you denied promotion? And others, you have promoted them, maybe promotion to him. At least from the date,
yes,
these persons are given promotion.
from that date he should get.
He should be attention.
He joined in the year 2019.
Correct.
Thereafter,
38 2019 he joined.
38 2019.
These persons subsequent to that,
Yeah, 2022.
yes, all they have been given promotion.
He was
I
promoted
should
to the
get promotion from that date, my lord. From that date.
That means from the date you were served
Yes.
given.
One more
That date should be given.
22.
1122.
It is there in the rejection order, page 60.
Now, has he been given promotion?
Yes, ma'am.
No, he has been given promotion.
No, from subsequent case.
With effect from 1 month?
No, I got promotion from 13/11/2023.
13/11/23.
23.
It ought to have been 1/1/2022.
Yes, ma'am.
Is it right? Is it?
No, my lord. I'm on 20th February, my lord. I got promotion 20th February 23.
You have been given.
Yes, ma'am. But they promoted on 30th/11/22.
30/11/22.
And juniors promoted.
Mr. G, the date is still beyond what to say.
Yes.
To your advantage. That has to be given.
That's to be given.
You were appointed as what?
Junior
assistant, now promoted as assistant section officer.
Yes, no. Assistant section also.
Yes, I'll give dictation. Give me the foundational facts whenever I ask. Kindly be seated. Shorn of thickness of the petition papers, comma.
My lord, little introduction subject to your lecture. In that paragraph, it is written that
Page number
60.
160.
Third paragraph, second paragraph.
16.
Yes, no, 60.
60.
That pursuant to.
Pursuant to the amended rule.
Yes, rule of 2022, the service of the 19th number of junior assistant newly selected by the Orissa Staff Selection Commission Bhubaneswar were regularized from their initial date of joining. Subsequently, they were also promoted to the post of section also with effect from 1/1/2022. But whereas the heads of the petitioner could not be considered for his promotion to the post of ASO as he had not completed mandatory residency period of 3 years as on 1/1/2022 as laid down under Orissa heads of department within bracket method of recruitment and conditions of service of junior assistant, assistant section officer and section officer of the head of 2019.
Because he reported for duty on 38/2018.
19.
Right?
19.
No.
38.
33/2018. That the OA was decided.
Yes.
And he reported for duty on 38/2019. 19.
19.
Not 18.
19.
19, because they offered my lord, they issued the order late, my lord. They issued the order
Of
late.
the pen 6 of the
Mistake of that was the binding, my lord. This.
But anyway, you have placed them above the rest of the people in the seniority list.
Seniority list. Will not say that. Reflecting that.
Order has to point out.
That is what I want to point out here.
Kindly be seated. Shorn of thickness of the petition paper book, the essential grievance of the petitioner is as to denial of promotion date, that is 30/11/2022, although promotion has been granted with effect from 20 February 2023. Learned counsel for the petitioner submits that when in the seniority list his client figures at serial number 2 above his juniors, the promotion accorded to the juniors at least should be the basis for altering his date of promotion from 20 February 2020. First off, learned counsel for the petitioner vehemently argues that pursuant to the advertisement dated 27/3/2013, he along with others were selected as junior assistant on 10/5/2015, and thereafter they were issued the appointment order dated 16/10/2015.
10/9/2015. Selection date is 10/9/2015.
10/9/2015. And accordingly, they were issued appointment order dated 16/10/2015, describing the same as contractual. First one. Therefore, petitioner and others had approached the Orissa Administrative Tribunal as it then was in OA number 7C of 2018, which came to be allowed on 13/3/2018, to the effect that the status of petitioner should be of regular appointment as distinguished from contractual. First, counsel submits that, repeats that, even if his client had reported for duty on 30/8/2019, pursuant to the OAT order dated 13/3/2018, he cannot be faltered in as much as the offer of regular appointment itself was made belatedly. First, so arguing, he seeks an order allowing the writ petition. Next paragraph. Learned AGA appearing for the OPs vehemently opposes the petition, contending that in the OAT order dated 13/3/2018, entered in OA number 7C of 2018, there is no direction that the petitioner should be given service or monetary benefits for the period that preceded his joining date, or for grant of notional benefits. First up, petitioner admittedly having joined the service on 30 August 2019, his claim for promotion with the retrospective effect cannot be considered. First, so contending, he seeks dismissal of the writ petition. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence in the matter as under and for the following reasons. First one, the facts, the foundational facts, that is 4.1 or something like that, are not in dispute. There was advertisement for regular recruitment issued on 27/3/2013. Semicolon. Petitioner along with others were selected in terms of select list dated 10/9/2015 as junior assistants for the post of junior assistants. First one. Appointment order was issued on 16/10/2015. describing the appointees as contractual, semicolon. The challenge to same by petitioner in OA number 7C of 2018, having been favored on 13/3/2018, the appointment was treated as regular and the petitioner joined service on 30 August 2019. First time. When others appointed in the very same recruitment process had reported for duty, even as contractual employees, what prevented the petitioner from following the suit, remains ununderstandable. First, be that as it may. Next point. Petitioner reported for duty with effect from 30/8/2019 and it was because of issuance of the appointment order pursuant to the direction of OAT dated 13/3/2018. First, no explanation is offered from the OPs as to why the OAT order was not implemented for more than a year. And therefore, they cannot take the benefit of their own wrong in implementing the OAT order after taking a lot of delay. First off, if that delay is kept in view, the contention of Lebanon EGA that the subject rules required 3 years of service, and petitioner did not have it, would fall to the ground. First. Next paragraph. Whatever be the matter, when the juniors are promoted as assistant section officers with effect from 30 November 2022, 30 November or January?
November.
30th November 20. You are right. You kindly be seated, sir. Yeah. That embarrasses me when seniors stand up.
Yeah.
Yes. 30/11/2022, petitioner ought to have been given the promotion with effect from that date itself, whereas he has been promoted only on 20 February 2023, which is ununderstandable. Except ritualistically quoting the extant rule requiring 3 years of service, the impugned order is not animated with the sense of justice. First off, it only reflects Macaulay's mindset and colonial hangover of the jurisdictional applications. that would be an error apparent on the face of the record. First, in the above circumstances, this petition succeeds in part. A writ of mandamus issues to which OPs? The
OP number 3, man.
OP number 3.
His director has.
Yeah. To OP numbers 2 and 3, I will make it. 2 and 3. To grant promotion, to alter petitioner's date of promotion as 30/11/2022 and grant him all service and monetary benefits accruing by virtue of that within a period of 8 weeks, failing which the delay would carry interest at the rate of 1% per mensum till actual payment is made, and that interest component may be recovered from the official's errand. Now, of course. Yes. Full relief cannot be granted because he did not report what you. Yes. Continuing. Yes.
Students reservation. What? For munificently viewed for the evaluation and dissemination of answers to the students, and if in the eventuality for evaluation, that was what it comes at this point, council for the university take people to take instruction. That's why the matter was.
What is this matter? Just refresh my memory.
Yes. This is not the past tense physics semester examination. They appeared in January 24. The result would not be published. That was the after the worship. Then this Hon'Ble issued notice to the university to apprise the status of the declaration of the result.
Yeah.
So they said that the university said they have published the result, but countering to that, I invited Dr. Stein attention to result, the letter of the college that the result was not published.
The results are published by the college.
No, by the university. By the university. They said that we have published the result, but which is countered by the college letter showing that no result was published. That invited Dr. Stein to 2 documents. Their document saying publication of result, and I invite you to kind attention to the letter of the college who wrote a letter to university for publication of the result until that date students are waiting. That is the case.
Why results are according to you? Why results are not?
Yes, my information. We persuaded with the university and all authority for declaration, but according to the university, the document was not uploaded, so it delayed the matter. But the college said in 17, soon after the exam, by 17 February 24,
they had uploaded all that.
Yes. So,
where is your university?
I am in
Patna.
It's not tonight.
Generally, he will be here, no?
Yes.
After lunch. Afternoon, because I have some orders.
Yes, I know. But it may be taken up.
Yeah.
The students have.
Yes, sir. Yes, item number 2 is there at 21.
Yes.
Is there in item number 22, which will.
Besides, I'll also inform them.
Yeah. You just inform me. Yes. You can take him for lunch, where you can whisper best words to allow him some
We are
sweet.
discussing the
Item 30? Item 30, my lord.
Last week from the government side. ITCO has not filed counter, but the thing is the ITCO, it has been allocated, the land has been allocated to ITCO. ITCO is beneficiary. Now, what of this related to the road? I'm not taking the case, because I want time to file the tender. Only this is.
Item 30, I'm appearing through VC, my lords. I'm sorry I could not appear physically, my lords. I've hurt my leg. It's always a pleasure. I've hurt my leg. It's always a pleasure to appear before your lordship physically, my lords.
Very good. No issue.
My lords, the opposite party number 8 has been described as a necessary party, my lords. Actually, we have filed an IA. The plot has been allotted to us. So, my lords, I may be implicated as a party because I am the necessary party.
Allotment is made to his client.
I don't know.
Yes, my lord. I have filed an IA.
I have no objection. I have
filed an IA 15359 of 2025, wherein, my lords, I have clearly averred and showed the EA, my lords, that the allotment has been made to us, that is Bhubaneswari Foods and Beverages.
You have said that the Diamond District, take a judgment of the Apex Court. Diamond District Cooperative Society versus so and so, where Apex Court, where allotment is made during pendency, allottee can seek a plea.
I don't have any objection.
No objection. We'll allow it.
But I can see that allotment.
Anyway. You file counter, but impleading application to any impleading application in IA number so and so, supported by affidavit, is filed. First, learned counsel appearing for the applicant submits that his client has been allotted the subject site. Why the order dated? Allotment letter dated?
Allotment letter dated 24/6/2025.
Written. And therefore, he becomes a proper party, if not necessary party, in the light of Apex Court decision in Rajia Begum. You have the Diamond District judgment. There was one latest judgment, latest 10 years ago. Diamond District. Now, the Diamond District Cooperative Society versus so and so, which I read. Anyway, Rajia Begum first. The learned senior advocate Mishra appearing for the petitioner and learned panel counsel appearing for the mediator
for ITCO on behalf of Jawaharlal Patnaik Senior.
On behalf of advocate on record, very fairly submit that application may be allowed and the applicant being voted to the name of the applicant being voted to the cost title. First, no prejudice should be caused to anyone by allowing the subject application, except that the cost title becomes little longer than before. First, in the above circumstances, application having been favored, the applicant is directed to be permitted to be added to the cost title as OP number
9.
OP number 9. First, petitioner to amend the cost title. Yes, when we'll have this?
1 week, 10 days given to review immediately after vacation and also
within 1 week. First, not immediately after vacation.
We have already filed a counter.
Which year it is? This is you can't notify. But the issue means it will be solely.
Actually, they've done so actually, they have committed a content to file a content application. The content application will also listed along with that because they have the government has violated the authorities have violated your lordship's order. For your lordship category, you had first category order that road nature and character of the roads are not being dismantled, but they have dismantled it. So have filed contempt note 431420. That may also added.
Call this matter after vacation. After holidays, along with
concession number 431420.
Right.
My lords, our names may be reflected in the cause list. We have given the Wakalatnama and the senior.
In your application itself, there will be Wakalatnama. Which year, man?
25 meter, but the thing that the road is being dismantled. That is my notion. So, other thing that the villagers are deprived of access to the area.
You see the application. Many others have been very poor banks.
Yes, supplementary is item 27. So,
Right.
Let's start with the facts again. Kindly have a glance to annexure 1 at page 15. There was an advertisement dated in 12/10/2012. 10/12/2012. Annexure 1 at page 14. This is an advertisement.
Walk-in interview.
Yes, my lord. For the post of
The first one is
to engage academic consultants, computer programmer, librarian, junior executive and librarian.
Junior execution and
Librarian. Yes, ma'am. My lord, thereafter, interview was held 8/1/2013.
walk-in interview.
Yes, ma'am.
Any judgment or any reports in the country as to what is meant by walk-in interview? Walk-in interview on?
On 8/1/2013 under Annexure 3 series, page 16A.
Who interviewed?
My lord, that is director and the vice chancellor.
No.
A director.
Okay, I'm going. The director of the DDC wrote Hon'Ble submission is, and I'm repeating for the opposite party number 2, 3, 4 in the first case as is of 19084 of 2023.
For the university.
Yes, sir. One is the Utkal University, and second is the registrar of the university, and third is the director of DDC course. So my humble submission is that the DDC
have foundational facts. We have foundational facts.
Yes, I'm going to foundation one by one. I'm going to that. What is going to submit? I submit second sense.
This was done by director. Why
which director? The director.
DDC.
Means?
My lord, that is Directorate of Distance and Continuing Education.
Yes.
And he prepared the shortlist.
Yes, my lord. Annexure 15 in my additional affidavit.
Shortlist dated.
Dated, my lord. Next is Annexure 15, page 12 in my additional affidavit.
What is the date of the shortlist? Was shortlisted with the information letter of 15/1/2013. In 2013. You saw a hard copy. You saw a hard copy to all the selected applicants.
The petitioners were selected.
Yes, sir. Among petitioner, other also selected.
Along with petitioner.
Other petition. One for the academic consultant, another for the academic consultant for history, and academic consultant for Sanskrit. Sir.
They are not people.
Okay. Here the Litun Pradhan is selected for the junior executive.
Let me place first.
Okay, point.
Select list was prepared on 15/2000. Then the selection was based on the table of which officer?
Vice Chancellor.
That was the on which date?
7/3/2013, where it was reflected that as per the order of the Vice Chancellor on dated 14/1/2013.
15/1/2013.
Yes, please.
How select list itself is 15/1/2013.
That is as per the order of Vice Chancellor 14/1/13.
Pursuant to that order, select list is prepared.
Yes, please.
Are you saying just by Andaz or
When it sits as a given date, we notice that shortlisted candidates were shortlisted.
shortlisted?
Yes, ma'am.
Then
Because I have annexed it.
okay. This is Alexa.
Annexure 15 under additional affidavit at flat 10. Yes, ma'am. As per the order of the Vice Chancellor on dated 14/1/13 and the subsequent approval.
What is that 14/1/2013 order?
Annexure.
You represent the university. Yes, sir. What is that order? You tell me.
Annexure 6, page 20.
Okay. So a humble submission is that it is the office order and it is order signature by the director. The letter dated is 7/3/13. As for the order of a vice chancellor, order dated 14/1/2013 is subsequent approval of a selection of an academic consultant.
14/1 order is what?
14/1. Yes, I'm saying that this order is just give the to the director of the DDC for the academic consultant, not related to his appointment. There is no concept of appointment by the vice chancellor. So one thing is that in this matter, in this incident, there is no role of the opposite party number 2 and opposite party number 3. One is the vice chancellor and another is the registrar of university. The fact is that okay.
The vice chancellor has not.
No, vice chancellor has no role and registrar has no role.
Registrar has no role. But they came to know on this appointment and other things.
No, it is not. It is just when the vice chancellor is the authority of the university, so they are related to the decision it was mentioned, but the signature by the director.
Yes, sir. Whether the vice chancellor is a blind and deaf man?
No.
Things like all organs properly.
No.
Yes, we do these things. So, according what is your stand? Don't say unless otherwise you enter witness box and cross-examine you. So, sir, in your objection statement, what is the stand you have taken?
My objection. My thing is that
argue on the basis of objection.
Objections.
What have you stated?
One thing is that the first point is there are no such type of posts, junior executive, in respect to the statute of university, the classification of posts. The second is there is no sanctioned post. And third one is the recruitment procedure of a non-teaching staff and the promotion is not in a proper procedure. And fourth point is the engagement is not by the appointment authority.
Who is the appointee?
Here is appointment authority is both the director of DDC.
Director
of DDC.
Yeah, he himself has done that, no?
Sir?
Director himself has done this exercise.
Director, according to his workload, and by taking the
No, I am asking.
yes, sir. Okay, sorry. Okay, sir.
Who is the appointee?
In this case, the director of the DDC is the appointment authority.
Therefore, the appointing authority has made the appointment.
Yes.
Whether procedure is followed or not, we will come to that.
Okay, sorry. Director of DDC. And is it? No. I'm looking about this. Yes, sir. Listen, in this case,
the director, in this one, director of DDC is engaged the applicant.
And
the competent authority,
who is the competent?
registered is the competent authority. Yes,
Which?
according to the statute. In my affidavit,
Not affidavit.
I give the annexure. In the affidavit 5/12/24, the page number.
Where are the rules? Where are the rules? We all yes, statute.
The Odisha University first statute, the chapter 4.
Odisha University is that first statute in 19.
Chapter 4.
Director, college development council, academic staff, college director, student development council.
11.1. Chapter 4. The heading is registrar. In para 11,
addition to the powers.
yes, point 2.
Broad challenge, sustained for controlling powers into the which is that? Appoint class 4 employees.
Yes.
But these are not class 4 employees.
Okay, I'm going to that. The question, the competent authority is registered. The registrar can appoint the class 4 employee of the university on the recommendation of the selection committee.
But these are not class 4 employees.
No, they are not class 4 employees.
Therefore, that is not answer. It is no answer. For these categories of employees, class 1, class 2, they will.
Yes, ma'am.
For them, who is the appointing authority?
So they are not coming under the class 1, class 2 because they are engaged according to the advertisement of it.
Understood. In employees in the university, there are other classes of employees, not only class 4 employees. There are many other classes of employees. Who are they? Who appoints them? University cannot run by class 4 employees.
In case of class 1, class 4 employee, the recruitment for the recruitment procedure, for the advertisement is there, the competent authority is only registered in case. So yes.
Register itself is the class 1 officer. That's for their statute.
I'm reading your statute.
So,
but when these statutes were made, it was 1990 statutes. It says registrar is the appointing authority for class 4 employees. But we all in the court hall know university cannot be run by class 4 employees. It needs other classes of employees. Which are those classes? Who appoints?
The procedure those.
You are not, if you do not understand.
I understand, sir.
Sorry. The question was another nonsense.
I was asking about the class 1 and class 2. There members, I think, so far as syndicate is concerned, section 2.2, chapter 3II 2.1. They have to create the post.
Creation of post is one thing. Appointing to the created post is another.
Creation of post is suggestion the government must be post.
And it's a simple question. Who is the appointment? Simple English, simple law.
My right, clear.
One Odisha University recruitment and promotion of non-teaching employees rules, where it is clearly stated.
That was, those rules are made on which date?
1991.
When you were appointed.
My lord, I was 2013.
30. Therefore, these rules were in force.
Yes, my lord.
According to those rules,
Yes.
who is the appointing authority?
See, officers declared such under the Act and statute, which they are reading just now. Under that, those holding class 1, class 2 post prescribed in the Schedule B statutes.
To the statute.
Yes, my lord, which I am saying, that is, my lord is holding at the last portion, the statute has mentioned Schedule B. Schedule B. After chapter miscellaneous Schedule A, after Schedule A, my lord. Schedule B. Yes, my lord. At the last, my lord.
Can you show me from the issue?
Yes, my lord.
Yes. My God, I have to take this one.
My lord, there under class 1 post, register is at number 1. And librarian is at 1, 2,
In the schedule.
6, 7, 8, 9, 10, 11.
Schedule to rules.
Schedule B.
Schedule B to rules. To the
Yes,
classification of post.
Classification post.
Rules. Register. I am not asking for register.
No, my lord.
Librarian fits into which class 1 or class
1. Class 1.
Librarian is class 1.
Yes, my lord.
Once. And junior executives?
Junior executive, there is no such post. My lord, I am saying so. Class 2 post, that is here, other officers equivalent in rank to the officers listed above. That is also there. And that is as per the syndicate.
That fits into class 2.
Yes, my lord, that is administrative officer. That is in the class 2 post. Because this is junior executive. At no stretch of imagination, we cannot say them as class 4 postman. Their designation is junior executive.
That we can call them as class 4.
Yes, my lord. My lord, that has to be read with this rule. Rule 12. Rule 12. See, which.
Who appoints them?
Yes, my lord. Success in the examination confers no right to appointment.
I got appoints. Who is the appointee?
Yes, my lord. I am selecting store. I am
direct to point.
Vice Chancellor. A successful candidate may be appointed subject to availability of vacancy, and if the Vice Chancellor is satisfied after such inquiry, he may consider that he is fit in all respect for appointment to the service of the university.
Which one?
My lord, 12. That is right and appointment and joining time. Right of appointment and joining time.
Find out.
See.
There is no assistance from advocates appearing for the university.
Sir, Hon'Ble Samson has happened.
You are not answering, you are not answered. Kindly do not waste time on that. Rule 12.
Yes, ma'am. 12-1.
12-1.
Yes. Here it is only written in examination.
Well.
Yes, ma'am.
So the Vice Chancellor happens to be the appointing authority.
Yes, ma'am. That is as per Rule 12.
Well.
Because it is clearly stated, my lord, above to that, 10, Rule 10, my lord can see recruitment to all class 4 posts shall be made by the means of a competitive test by the appointing authority. Consciously, this appointing authority has been mentioned against the class 4 employees, and register is the appointing authority. That is,
Therefore, he cannot appoint.
yes, my lord.
The employees of his own cadre.
My lord, another submission before your lordship. Register himself in the class 1 post.
That's all.
And
He cannot appoint his own class.
Only librarian he cannot appoint. And my lord, I will come to that register, how register can delegate to the director
No,
to
not
give
at all.
appointment.
The registrar has no role
No,
because
not problem.
even the class of employees
Yes,
is not within the powers of the registrar.
yes.
So, therefore, their first contention that competent authority has not appointed, that is liable to be rejected.
My humble submission, what is
Sure, where the Vice Chancellor looked into these papers and approved your appointment?
My lord, it is only in that office order. It is written on 7/3/13, page 22.
Page 22.
Annexure
Go there.
6.
Go to 22. Give the paper. First paper. This is Mrs. Malini Sahu. No, Miss
The two problem. My lord, can we see 6, 7, 8? Assis Kumar Misra. Nitun Pradhan is my lord, holding 19084 of 23. First case.
The other names are appearing here, na?
My lord, those are the
One second.
finish.
He's not asking the question.
Sorry.
Other names are here, na?
Yes, my lord.
Of them, who are they companion writ petitioners?
Yes, my lord.
No.
Other two, along with Nitun Pradhan, Assis Kumar Misra, and Mitali Sam.
All three, 6, 7, 8.
Yes, my lord.
This is annexure.
Annexure 6, page 22.
WP
19084 of 23.
23. Yes. When this is seen by the Vice Chancellor, you mean to say, since that mentions Vice Chancellor's name,
Yes, ma'am.
It is done with the knowledge of Vice Chancellor, is your contention. How you have explained this document in your objection statement?
So my humble submission is that
No, answer the question. No, yes, answer question. Then you can make something. How have you answered? How you have described this document in your objection statement?
so relating to
annexure
the annexure 6A/3 of 2021 to page number 2221 in my reply to the affidavit on 5/12/24. That one is the classification of post. Such post was not existing in the university.
Where is it?
That is the
How do you have described annexure 6? Annexure 6 says something. It is in English.
I'm going to read it.
Yeah. How you have treated it? How you have construed this annexure?
So related to this Annexure 6, yes. In my objection, it was stated that the DDC has read, as for the order Vice dated 14/13, the subsequent approval of the selection of academic consultant, librarian and junior executive held on 9/1/2013. The joining of the following 8 number of candidates by the office letter have been accepted. So the initial engagement is only for period for 3 months.
You have not denied this document.
I am not denying this topic because the Vice Chancellor is the authority of the university. So after approval, after selection and of the applicants through the director of DDC, so he approved it because he is the authority of the universities.
Vice Chancellor approved.
Did after DDC selection the candidates, that selection list sent to the higher authority. So the Vice Chancellor. So
Vice Chancellor. This was sent to the Vice Chancellor.
The Vice Chancellor had approved that and sent to the director to the.
This is approved by the Vice Chancellor.
Sir,
this Vice Chancellor has seen this document.
Yes, Council.
Council for the university
and director is saying this
on being repeatedly asked. Repeatedly answers that the document dated 7/3/2013, which is office order that 6 issued by the director, has been seen by the Vice Chancellor. Since court is online mode, separately it needs a director. Then,
yes, thereafter, my lord, the petitioner tendered for joining report on 15/1/2013.
They joined on 15/1. All petitioners.
Yes, madam.
All petitioners joined on
15/1/2013.
Just to make me also. The advertisement was issued on 10/12/2012.
Yes, ma'am.
At the next 1. Inter alia for the posts of junior for the posts of librarian and junior executives. First up, walk-in interview was conducted on 8/1/2013 by the Director of Distance Education.
Distance education, Directorate of Distance and Continuing Education.
It is director, not directorate. Director.
Yes.
Is that directorate of Director of Distance and Continuing Education on 8/1/2013.
8/1/2013.
First, the select list was prepared by the director and director with the approval of the Vice Chancellor. In terms of Annexure 15, dated 15/1/2013, wherein petitioners figure in go to that Annexure 6. 6, 7, 8. Figure 6, 7. First one. Serial number 6 is librarian.
6 is junior executive.
6 and 7 are 6 and 7 are junior executives, and 8 is librarian. First one. Thereafter, they joined duty. They reported for duty on
15/1/2013.
15/1/2013. Where is that document?
Yes, it is at page 16. Page 16, annexure 3.
Why this is duty report?
Yes, fine. Joining letter for
In the solid joining letter for the post of junior executive, we mentioned in the subject.
It is issued by whom? Petitioner.
Petitioner, joining report.
Which petitioner?
That is the petitioner. First
Executive.
petition.
Assistant executive.
Yes, ma'am.
Junior executive.
Yes, ma'am.
Junior executive. That is all they reported for duty same day.
Yes.
All they reported for duty on
15/1/2013.
15/1/2013.
And we are allowed to interrupt. The third petitioner has joined on 16/1/2013. That is Vitali Shah.
Even 15/1/2015. Now petition.
Anyway, one day is the
Yes.
difference between you. 15/16.
Would your lordship proceeds further? I would like to present some documents, but they have given some undertaking as regards our letter, the temporary nature of the post, which they have agreed. Your lordship kindly tell us.
Yes.
In these two.
Now, have you filed the objections?
Yes, ma'am. Sir.
Have you annexed these documents in your
No, these documents were not available.
No, I not sick.
Not with me then, but that was provided to be lent.
Why they were not provided earlier, along when counter was printing? This is not tea shop. This is a court of law. There has to be some procedure. At least one memo with leave, asking leave. You cannot pass on documents, no offer documents across the bar.
As per procedure, that has to be filed by when. I just wanted to bring to your lordship notice. I'll file that in due
This
procedure.
is for what effect it is?
It is the letter given by the second page. Your lordship turns to
Say.
is the appointment letter given by the Directorate of Distant Education, and the third page happens to be joining. And in the first page, there's an undertaking where it talks of temporariness of the nature of the
Just file along with.
months.
Panel counsel submits that there is a specific undertaking by the petitioners that their appointment is purely on temporary basis.
Mixture 4, page 17. Where the remuneration and wages.
Consider. Next point. Which are the rules? Name is what is the title of the rules?
Recruitment rules, promotion.
It's Orissa University's recruitment and promotion of non-teaching employees rules, 1991.
Orissa University's recruitment and promotion rules, 1991.
Promotion of non-teaching employees rules.
Promotion of non-teaching employees rules, 1992. These rules are made under which section?
These rules under the rule making power.
Now, these rules have been promulgated.
Statute 3 of the Orissa University's first statute 1990.
Statute 3 of Orissa University first statutes 1999. Statutes are made under which section?
We define in chapter wise.
I am asking.
And
section.
That is subsection 3 of section.
These statutes are made under subsection
3 of section 24 of the Orissa.
made under section 24(3) of the Orissa Universities Act 1989. Who makes the statutes and who makes the rules? Statute by the government. Statute is by the government. Which section?
It's that is statute must the information of statute must section of the Orissa University Act. Subject to the provision of the Act.
Statutes are made by the government.
Subject to provision of the Act. The statute shall provide the following.
No, this is the who makes this statute?
It should start by the government in the Education and Youth Services Department.
Where is that section?
Coming of statute, minus 1624.
State government the following statute.
Which section?
This is
That is as per subsection 3 of section 24 of.
Give that section. What is that section?
Subsection 3. This first statute shall be formed by the
state government.
By the state government. Rule by law.
Rules are made under which section?
The rule by law, so far that recruitment rule, which is directly made by law on approval of the chancellor.
Chancellor power and function of the syndicate at the clause 20.
Now you say these rules are promulgated under statute number 3.
Of 3.
Whether government can delegate for rule making power to the statute. Rules are made by whom?
By the government.
Government only.
Statute, the rules man. The rules man is that what I understand, I got the point that I'm missing somewhere. The rules are generally framed by the university and is getting approval of the chancellor.
We have to answer it by seeing the sections. There is some intricacy in what.
Yes,
that is the reason I will not now reveal it to you. The government can make statutes, I can understand.
Yes,
where is the power given to the government to delegate rule making power under the statute?
Okay. Statute neatly.
That is given. Whether the section gives that power. If otherwise the doctrine of delegatus non-potestas delegare will come into play.
Yes, ma'am.
And all your defenses will fall down. How government is enabled to, it can make statutes, I can understand.
Yes.
Whether government will delegate power to itself, it is unheard of in administrative law. Therefore, I am asking, who made the rules?
I am answered. Just because reading between the lines.
Chancellor makes these rules. Then your answer that it is also made by government is not correct. Then the answer that government has made is not correct.
Please to
the Chancellor makes the rules. Which is the section? Which section? Statute.
Of Orissa University recruitment. So not employees.
Rules. These rules are made by Chancellor. Where is the power to the Chancellor? Who is the Chancellor in your state? In our Karnataka state, Governor is the Chancellor.
Governor is the Chancellor.
What are the powers of the Chancellor under the Act?
Chancellor. Power. The Chancellor is section 5. Section 5.
Give that statute. Act.
University Act. Section 5.
Section 5. This is statute. Orissa basic education. Odisha University Act, Section 5. Whether statutes are defined, rules, statutes, are they, let us go to dictionary clause of the Act now. Go to Section 2.
The section.
Affiliated academic college, constituent college, director.
Statute one is
Prescribed by statute, that said the status.
statute one is M, 2M.
That is alphabet M.
2H.
2M.
Prescribed means prescribed by statutes. Twice it is available.
Definition of statute is that M.
Statutes means the statutes of the concerned university made under this act. Syndicate means the syndicate, teacher, university. Now there are two words. See there. 2H. Read 2H. 2H. Prescribed means prescribed by statutes. Because under the General Clauses Act, prescribed means prescribed by rules made under the Act.
Yes.
This is the difference.
Yes.
So now the statutes are made under 24(3).
Yes.
First statute.
Yes.
Then rules are made under by the Chancellor under which section?
That means section one. And that section I think is not provided.
Where are the powers of the Chancellor?
Power of the Chancellor is 5.
Let us see that section.
It's on 5.
Does it give power to make rules?
That I think is not there.
Where is the rule making power in the section? Generally, all statutes will have rule making power. Which is that section? Go to section 21, which you have not brought to my notice.
Section 21.
Yes, you are only operating in statute and subordinate legislation. Go to section 21.
21.
Yes.
It's on 21.
Yes. Please read. Appointment of officer, teachers, and other employees of the university. Unless otherwise specified in this act, all officers of the university shall be appointed by the Vice Chancellor on the recommendation of selection committee consisting of director, the registrar, one member, and so it's indicate from so and so, wherever necessary, 2 experts appointed by the Vice Chancellor. Therefore, section 21 makes the Vice Chancellor to be the appointing authority.
On consultation.
Yes. You made me to do a lot of circus on that without reading the section.
The selection committee.
Section 21.
Selection committee.
Modalities of appointment are different. To the question, who is the appointing authority?
Yes, that
is answered by the legislature. And you are all, till now, I have to make so much jugglery with you people.
I'm sorry, man.
Section 21 of the Act makes the Vice Chancellor the sole repository of power of appointment, be it academic staff or non-academic. It also prescribes the modalities of appointment. Therefore, your contention, registrar is the appointing authority, falls down to the ground. Therefore, contention of the panel council that it is the registrar who makes the appointment would fall down to the ground. Notwithstanding the, which is the statute, what has been stated in the university for statute, because statute being a subordinate legislation, it cannot override the parent act.
There are only some minors have already referred to 21.
Yeah.
21 3 specialty selection committee.
Correct.
On which recommendation the Vice Chancellor is to proceed.
Therefore, I said yesterday in Marathawada, I have
87,
Apex Court said
87.
the Vice Chancellor is the conscience keeper of the university. There is such a sentence in that.
Yes, 87.
You got the judgment?
Yes.
Section 22 provides for creation of courts by the Chancellor and prescribes the modalities.
21 3 minus 10.
21.3 selection modality.
Selection committee.
That's what.
Come. 22 3 of the post.
Para 18 and 19.
The approval of the state government.
Paragraph number?
Chancellor University is thus the conscience keeper of the university in constitutional rule.
And the constitutional ruler.
Yes, ma'am.
These are the words of the Supreme Court.
He is the principal executive and academic officer of the university. He is entrusted with the responsibility of overall administration of academic as well as non-academic affairs.
That's how Apex Court is.
That is our university act itself
Provides for.
This is that my lord 21 3.
21.3. That is the selection committee.
Selection committee recommends, then Vice Chancellor acts on.
Correct. That is for regular appointment.
For regular,
These are temporary appointments.
regular.
Because the university was the nascent university.
Right, ma'am.
Therefore, it's a nascent, it's a new university.
Oh, yes, yes.
New university. Therefore, when the new ship like Titanic is drawn to the sea, Irish sea, much measure of power avails with the pilot. Where these powers, because of that one,
Yes.
that way it is done. First statutes are made by the government.
Yes, ma'am.
Then subsequent statutes are made by whom?
Subsequent statute has not been noted.
I'm asking you.
That's the only statute.
This is the only statute. How long they will continue?
Religion post minors unless repealed or unless something. That will move time limit fixed minor.
Since 12 years, my lord.
Wow.
No, you are not answering the rule-making power. The rules are rules. What rules? No, regulation making power is set.
Regulation making power is there.
Rules are not there.
Rules in respect of that employees minor. That is there in
To regulate the conduct of university employee.
24
Rule A.
24 to A.
A. G. Rules to regulate the conduct of university.
Rules to regulate the conduct of university employees. Conduct rules.
Conduct rules.
That's a post appoint.
Post up. But a rule relating to my appointment, there is a provision that is his statute, D3.
Big three is rules.
Statute that authorizes the on approval of consultancy firm rules from
No, very good. That power given under section 24 to the government to grant rule-making power to the chancellor.
The chancellor. That would be an act manner that is not.
Then we cannot give more importance to the rules, although they are not charged. You have to show the source of the rules.
Yes, I also provide. The statute should provide.
No decision of this court who has examined all these aspects.
No,
there must be. All these aspects have not been examined.
Minors goes into deep into the matter. It should say anything more about that.
No, just like, because many matters of university come before me. You will say something and then they will say something. I should do the job. Therefore, I wanted to, not only for this case, just I wanted to know how university function and how university's panel councils also function.
Then statute assemblies.
Class 3.
Class 3 classes.
Class 3 classes. That is locked up in appeal. That is locked up in
that refers to section 21.
21 of 19 statute.
1990 statute. No, section. No, section 21. Not referred. How long they have been working now? Well, and have you regularized services of other employees? No. What one example?
16.
So those petitioners submitting the fact that some employees are regularized. Those employees are initially appointed through the competent authority and they are into contractual.
Who appointed?
Registered. Competent authorities registered according to the Orissa University Recruitment Promotion and Teaching Rules.
No, rules will not look it now. Because section say at the vice chancellor.
So vice chancellor did not.
Yeah. Then there are also that your contention falls to the ground.
Vice chancellor minors to file it. Generally, minors know that file is to the vice chancellor. Vice chancellor approves it. Thereafter, it is to communicate.
No, section is not there.
Vice chancellor is to do.
Section wherever they wanted approval.
Yes.
Go to section 23.
Yes.
They have in so many words said
yes.
Approval, etc.
Yes.
But that is not the case in section 24.
No, it is not
21.
It is not 21. It is not there.
Therefore, they propose then approval these things. That question will not. Appointing authority means appointing authority. He is not approving authority. He is appointing authority.
I am not sure about that. I am not disputing about that status of the vice chancellor as an appointing authority.
Right.
Once appointing authority does it and it is being communicated by the registrars. That is what.
Registrar is only a big postman.
That is exactly my understanding.
He is a big postman under the scheme of the act. He cannot do anything. Your statute may say so many things, but statute cannot override the parent act. That has been the settled position right from the days of Free Delhi Laws Act. The reference. Once. Now you said the employees were appointed by the competent authority and therefore they have been regularized. Which competent authority they were appointed? No, he said that. So you say all those employees were appointed by competent authority, therefore they have been regularized. Which authority had appointed?
So according to the fact given by the university, the registrar is the competent authority, then as for the High Court order, they regularize the 80 staff, 76 staff, and they regularize according to the High Court order.
But now, yes. You can tell Vice Chancellor who is the appointing authority. Still you will argue that
But with the fact in
to understand law is you cannot just be swayed away by what your registrars will say. Registrars in the university, most of the universities are made by SPCs and FPCs. Don't go with it. Do research, as I have done now. How analysis of the law will be done. That's right. Therefore, your first argument that they were appointed by competent authority and therefore they were regularized, unless you now show they were appointed by the Vice Chancellor, that contention is not available to you. And if you say that other court has done it has done it because you misled the court. You have misled the other court, saying that they are appointed by the competent authority. That was not examined. Now I have examined. It is only the Vice Chancellor who will appoint even the sweepers in the university. Huh? Even for class 4 employees, notwithstanding what the statute will say, statute cannot override the Parent Act. That's it. That's how Jain and Jain on administrative law, Wade on administrative law, IP Messi, SP Sate, all they say that. They have dedicated one chapter for that.
Registrar is appointed for class 4 employees.
Because statute said like that. Yes. Therefore, he is making the submission. But it's a question of law now. All right. Come to the point. Anything more to be said now? On law, you have to say on law, I don't dispute facts. The other day, the government advocate yesterday, the advocate was intervening. What is his stand? What is your stand?
What document?
For what purpose?
Fairness allowance, date. It's been extended to these employees.
Wait.
By the syndicate, where the Vice Chancellor is a member.
He happens to be the not only member, he happens to be ex-officio chairman of this syndicate.
Yes. At my additional affidavit.
DA is extended by the syndicate
on 21/6/70.
Even 6/2007.
Yes, ma'am.
And syndicate is the ex-officio chairman of the syndicate. Which section? Generally, in all university statutes, the ex-officio chairman, VC. Yes. Go to the syndicate, composition of syndicate. Syndicate shall be the administrative body of the university. Senate shall be academic body of the university. Huh? Section 10. Read who are the comprising members.
Indicates the consists of the following members.
Yes.
It's following members, namely ex-officio member, A, the Vice Chancellor
yes.
of the concerned university, the director, the chairman post of PG Council, the principal of
Therefore, Vice Chancellor knew that these persons were working, and thereafter that the syndicate took the decision to extend the DA allowance. Yeah, that is annexure.
Annexure, my lord. That is annexure payment. Annexure. Annexure, my lord, 14.
Annex 14.
Yes, ma'am. Comptroller of Finance is also a member.
Controller of Finance is also a member.
Yes, so a member.
So all together they have taken that issue. A member. That is which section it is? Section composition of syndicate.
That's composition of syndicate. Composition section 10.
Section. Therefore, somebody's contention that these are distant bodies, the Vice Chancellor did not have any idea as to about those bodies, that will fall down. Yeah, that was made sufficient.
What my says is correct.
Yes.
But as far as section 10 is concerned, the register and all, they are not the member.
Section 10. No, in the syndicate.
Syndicate one.
Yes.
I mean syndicate one.
Syndicate director is a member.
Director is a member.
Member.
Director is a member. Vice chairman is a member. The council chairman is a member.
Yes.
The director is the director is not the principal. Others are members. But so far as the register, he is not in.
The register, therefore, I said register is a big postmark.
It is postmark.
Yes.
Annual increment, the tune of 3% was also allowed.
Annual increment was given by whom?
By this city.
On
21/6/17.
annual increment. DA and annual increment.
Yes, ma'am.
Dearness allowance. You said dearness allowance.
Yes, my lord. So, my lord, that is so minimum grade pay of 5,400.
That is grade pay.
Yes, my lord. Grade. Sorry, my lord. 5,400. After adding to the basic, my lord, 15,600.
Grade pay of 5,000.
5,400.
Plus increments given.
And they are also covered under EPF.
They are covered under EPF
Yes.
also.
Yes, ma'am. I have annexed those documents.
That decision is taken by the syndicate.
Not syndicate.
By whom?
It is my lord, that is under the vice chancellor.
By the vice chancellor.
Yes, my lord. But 28/10/2014. Should code series.
2014.
Yes,
But
ma'am.
that is not for you. That is for class 4 employees.
My lord, it is three, my lord, junior executive and acting.
Librarian also.
Acting wise.
You are saying, but not designation.
Designation extended this benefits junior executive also.
EPF.
Yes, my lord. Page 17 and 18 of my requisition.
All right. I have understood your case. Now kindly be seated. Yeah.
So for director, implementing the syndicate, this director is not director of distant education, director of higher education. Director of higher education also. That is
Where is director of distance education? Where is the designation?
Yes.
Director of distance
No,
education.
that is not there. Director, definition of director is there in section 2.
No, section 2, all right. I have seen that. But the director of distance education and the continuance of education, under which, where he figures in the statute. Where does he figure in the statute? There must be. Otherwise, university will not do that.
Director documents of that is college.
Go to the schedule. Yes. In the schedule, the director of distance education is mentioned.
Exactly.
See, but generally, director of distance education is from what postal is kept there, we can move from the academic side. Not the academic, from professor, from reader, they are posted as the director of manager. This is not a regular appointment.
Section 2, that you have been repeating again and again. Section 2, you said director definition in
Director
direction.
higher education.
What is
If
Section post minor under class 1 post. Though DDC director is not mentioned, but on the bottom, other officers equivalent in rank the officers listed. It is as per.
any power to delegate given to vice chancellor? Our vice chancellor may delegate his powers to XYZ. That delegation section is there. Some anyway.
that power delegation,
Just looking.
with myself, section 6.
the subsections 11, the executive authority of the university shall vest in the vice chancellor.
That is exact matters with reference to that issue number also. But that all these matters, the power of the vice chancellor is almost one second to the decision matters of our university.
Yes. Yes. What are your grounds of objection?
We have so many 4 points.
Yes. Number one.
Number one, so such type.
You give dictation. You are his tenor. Yeah, give dictation. Yeah. First one. Articulate. No, you should articulate the objection. So that we can already have spent a lot of time now. Yeah. The first contention is what?
No such type of posts are existing according to statute.
Number one. Panel counsel for the university submits that there are no such posts against which the petitioners have been working, and therefore the question of regularization would not arise.
No sanctioned posts are there.
Yes, but that is not no post nor sanctioned post. Next.
Third point after this.
Yes, first point, only one point.
Then are these a competent authority, not according to the competent authority.
No, that you should show who is the competent authority. I have shown that the vice chancellor is the competent authority. Therefore, on that, don't spend time. Go to next point.
Next point, in the appointment letter, they mention that it is not irregular. You can't claim regulation at all. So, in respect to that, so he has no right.
Petitioners have undertaken at the time of their engagement that they would not claim regularization, and therefore they are stopped from maintaining this petition. Okay. Next point. That's all. Okay. Any other point? Any university point? Any other? But do you want to say that?
In fact, once I made it very clear, it's so far that item number 1 and 2 are not there. Other items, another item is there relating to some other issue.
But I make very humble request. All panel advocates appearing for university authority, boards, they should be thorough with the legal literature. Advocates may not be, but panel advocates should have accumulated vigilance,
they are
accumulated expertise. Yes, government.
No. My point is that here in this case for regularization is considered. Of course, so in respect of the BDC, not in respect of others, because in respect of BDC, what I understood from their records, that there are some transactions and some communications and some decisions at the level of the vice chancellor, even at the level of the syndicate, but not in respect of other organizations. That is not there before on the report. In respect of other items, that is there. So for these 2 items, the BDC appointed it on approval of the vice chancellor or syndicate, not against the existing faculty, but minors should be taken note of. But fact remains, they are posted as a librarian class 1 post, and the class of librarian is there in the list. Other post, that is the second post, that is not there in the list. So for the item number 1, that is not there in the list of the posts That is
available to the university. Available to the university. Executive, some executive, available to the university. And these posts have not been created either by on approval of the chancellor or of the government. Because by chancellor is to approve, then government is to also confirm. Because ultimately government is to add it in the gratinate.
Now, where did you tell the government? We have been engaging the services for so many people to run the university.
Yes, they have not.
Therefore, you create the post. Where is your communication to the government? How government will know what is the requirement of the university?
Yes, that is the thing. What they have to say, else I have not gone through their record. Just to point out.
Due to workload, or requirement of average flow data.
Therefore, there is workload now.
Please let us complete.
There is workload.
In case of the
there is only one. I have a small submission, one submission to their support minor.
Yeah.
These are all class 1 and class 2 courses.
Correct.
They are telling regularities.
Yeah.
But so far, Umadevi and other places and all these things, class 3, class 4 post, I understood.
Yeah.
But class 1 post means without following the procedure and then appointing, that I appeal to my lord's concerns. I appeal to my lord's concerns.
Is it your guess that they do not possess the requisite qualification?
They might be possessing the requisite qualifications. Suppose
no, I am asking you.
That they have to say, my lords, I am not.
Do they have requisite, what have you stated in your objection statement about qualifications?
You don't object to their qualifications.
Huh?
No, you don't object to their qualifications.
Learned panel council appearing for the university, in all fairness, submits that the petitioners have requisite qualification for doing the job which they have been doing since last 13 years, up to 12 years.
It is also my humble submission.
But even this question will not arise because only if posting is sanctioned, then question of prescription of qualifications will arise.
Subsequent.
That is what librarian post,
not a direct
it is the best level post.
It is not a best level post.
This is a promotional post. There is a hierarchy. There is additional librarian. Then they will
where is that?
That the government
may have many other.
The government
in the university is not an extended department of the government.
No.
Therefore, government cannot control the university.
Government cannot control them.
It is an independent statutory.
Yes,
it is not department of the government.
Just not independent. But for the post of concern, government they request the government approves the approved post.
But where have you requested the government?
They are that there is a recognized positions when what are the posts available. They should have not
Dedicated summit.
They are not submitted anything. Learned panel council on being asked, answers that the university has never sent any proposal to the government seeking creation of the posts or sanction the posts. Okay.
That I would like to add.
Yes.
Even if which your has been brought to your notice as regards approval of the vice chancellor, etc. In these cases, but yet the EDC is a body, is a constituent college under the university. Like there are, as your lordship knows, there are many colleges affiliated to the university. So is the case here, and the director on his own.
Are they affiliated colleges?
Constituent college.
Constituent college, Apex Court said, is part of the university.
Well, because the affiliation power, etc.
Affiliation is different. A constituent college does not require affiliation. Only other colleges require affiliation. Yes. No, there is a settled position now. And I think Bhartiyar University versus State of Tamil Nadu, something like that. That may be. Exactly, I do not know. But there is such a decision of the Apex. It's a constituent college of the university. Therefore, question of affiliation will not arise. Affiliation arises where other than constituent college is established by private body, then it seeks aegis of the university.
As if I am allowed to
read section itself, there is a provision in the act itself. affiliation is there. Maybe powers of the Senate, it may be. Power to grant.
Question is maintain postgraduate degrees, constituent colleges, schools and hostels.
What about the affiliation? There must be some section in the university. Without affiliation, it is like children going to school without uniform. It is so much part of the university function. There must be a section. Just look into it and tell me.
Statute. Statute 170 that
Provides for
that admission of colleges to the university. Otherwise called applied affiliation. Admission of the institution as colleges. The statute 170.
that is affiliation.
That is. Means 173 means the award application body.
173.
70. The application for affiliation of the information to the university. Affiliation.
That is affiliation. That they are not for the colleges established by the syndicate of the university. Take. Do you want to say anything?
I have the instruction, my lord.
Yes.
And I started.
Give that.
And I have talked to the department, they said me this instruction.
Yeah.
They said that neither the university nor any that DTCE, director of DTCE, they have not taken any approval from the government or sanction from the government to appoint anybody.
Very deep.
We have silent.
Which section says for appointment, approval of the government should be taken?
In the sanction post, it is necessary
For
financial implication.
no, which section says? We don't know all that. Which section of the university says that the University Act says no appointment shall be made without prior permission of the government?
They will do that, but without sanction from the government, they will. Otherwise, financial implications, government has to.
We do not. The university has to sell its building and give the salary and other. We do not. Unless section says that otherwise it becomes a part of your department. University is not supposed to be your department at all.
It is
an autonomous body.
It is autonomous body. Independent body.
They are not bothered. In fact, in English Parliament, they passed a resolution saying that Margaret Thatcher should be given a doctorate. The university said, who is this parliamentarian? So it is the university which will decide. We don't give the doctorate.
That's all right.
Yes.
That is what my instruction is. I have got nothing to do with them.
Take now. Petitioner essentially to have a direction to the OP University and to its officials to regularize their services or absorb them in regular services with effect from the dates of their initial engagement. Firstly, petitioner in all these petitioners, participated in the walk-in interview pursuant to advertisement dated 10/12/2012 at Annex 1. First time. This walk-in interview was held on 8/1/2013 and on the instructions of the Vice Chancellor, the Director of Distance and Continuation Education.
Director of Distance and Continuing Education.
Director of
Directorate.
Office cannot be Director of Distance Education, Distance and Continuance of Education, prepared the select list on 15/1/2013 and name of the petitioners figured failed. First one. Petitioner Mrs. Mitali Sahu was selected as librarian, and other two petitioners were selected as junior aides. First one. This document or its content are not disputed. First one. Next paragraph. Learned counsel for the petitioners vehemently argues that his clients, having been duly appointed on the authority of the Vice Chancellor after due selection, have been serving the university uninterruptedly and sans any complaint. First one. The syndicate, by the resolution dated 21/6/2017, has accorded the grade pay to inter alia to these petitioners, and that by the decision dated 28/10/2014 admitted these petitioners to EPF scheme. First, they have been regularly working, and the university has been in the perennial requirement of their services, which were practiced vouched by the very continuance beyond it. First one. Therefore, the council submits, they should be directed to be regularized in service. First. Council drew attention of the court to the relevant provisions of the Orissa Universities Act 1989, correct? 89. 89, the Orissa University first statutes and the Orissa University appointment and promotion of non-teaching employees rules 1999. First, she also pressed into service the apex court decision in Marathwada University versus who? University versus Sheshrao Balawantrao Chauhan, 1989, they are 1989, SC 1582, more particularly paragraphs 18 and 19 in support of her intentions. First, next paragraph. A battery of panel lawyers and learned AGA opposed the petition on the following grounds. Number one, petitioners have not been appointed by the competent authority. Semicolon. There are no sanctioned posts against which their services have been engaged all through. Semicolon. The higher rank officials like librarian and assistant executives ordinarily cannot claim regularization of their services since they are high-ranking officials, and therefore a due selection process is a sine qua non. Petitioners are not justified in placing reliance on Annexure 4 series, whereby lower rank employees have been regularized in service, the facts of those employees being miles away from that of these petitions. First, you said Annexure 4 series yesterday. Anyway, just look into the just look into the directives. Yes. Correct me. Next directive. Lastly, they also pressed into service the decision of Apex Court in state of Karnataka versus Umadi. First. Next. Having heard learned advocates appearing for the parties, having perused the petition papers, and also having adverted to law and rulings, this court is inclined to grant indulgence in the matter as under and for the following reasons. Number one. The first submission of learned counsel for the petitioner that under the provisions of Section 21 of the 1989 Act, the power of appointment is vested in the Vice Chancellor of the University has full force. Section 21 for ease of reference is reproduced. First one. But not 21, no, powers of power to appoint was given, which one? With that, the Vice Chancellor shall appoint. That section was there, no? 21. 20. Reads as answer. First. The text of this section being as clear as gazetting quarters does not require any interpretation. First now. The vehement submission of learned panel counsel Shri so and so appearing for the university in one of the matters that there are first statutes of the university promulgated by the government under section 24(3) and under statute number 6, the power is given to the registrar to make appointment is thoroughly misconceived. And reasons for this are following. Firstly, the statute is the child of parent act, and therefore it has to be subservient to its mother. First, when Act empowers the Vice Chancellor to make appointment of all employees of the university, comma, what statute says in variance pales into insignificance. First, in the instant case, the advertisement having been issued, comma, the walk-in interview was conducted, and obviously it cannot be by the Vice Chancellor, who has onerous responsibilities, and therefore it was done by Director of Distance, etc. Education. First, the select list refers to Vice Chancellor's order dated 26/9/2014, and therefore it can be safely assumed that the director acted as his extended arm to conduct the walk-in interview. First, it hardly needs to be stated that the procedure of walk-in interview is not alien to service jurisprudence. First, it is a kind of minimal selection process ordinarily undertaken when regular recruitment process cannot be immediately resorted. First, therefore, the first contention that the petitioners were not engaged by the competent authorities is liable to be rejected. Next one. The second contention, which is nothing but an offshoot of the first one above, is that under section 24(3), 3 or 4, 21(3), a selection process has been mandatorily prescribed, and that contemplates constitution of a committee which has to undertake it. And that having not been done, the
21(3) refers to selection committee for the purpose of appointment of teaching staff.
But you said
no, that is the appointment of teaching staff.
Then that is also not applicable.
It's not applicable.
Then you are asking me thrice.
No.
For selection procedure.
No, the selection procedure prescribed for the teachers.
Yes, not
non-teaching staff. There is no selection procedure prescribed. They follow the rule.
The selection process has been mandatorily prescribed and that contemplates notification of information which is to undertake and that having
not been done. First, this selection process is only for appointment, for selection and appointment of teaching staff. And therefore, that would not come to the rescue of the respondents. Next point. It is not the case of the respondents that the services of these petitioners are not required. First, in fact, learned panel advocates, in all their fairness, specifically stated that the services of these candidates is required for the university. First, however, learned AGA Mr. G submits that the university had never sought for sanctioning of posts, nor for the permission to engage the services of employees like the petitioners, and that since it is the state which funds the university,
Section 22 of the Act, University Act, 1989, it speaks like this. All posts of officers which cannot include the Vice Chancellor, that says, the teachers and other employees of the university shall be created, and the scales of pay of allowances attached to such posts shall be determined by the Chancellor, subject to specific allotment of funds to this purpose in the budget of the concerned university, and shall be in accordance with the yardstick formulated by such university with the approval of the state government. 2. Till such yardstick is finalized, the yardstick for teaching posts prescribed by the University Grant Commission, and then for the other corresponding posts under the state government shall be followed. Whenever posts are created beyond yardstick approved by the state government under subsection 1, prior concurrence of the state government shall be obtained. So my solution is they have not
presses into service the provisions of section 22
the university
of the Universities Act in support of his submission. First off. Whether in any of the university's bodies secretary of the government is a member? That's it.
The direct secretary. And all his nominee.
No, there must be some, in some statutes I have seen, some acts I have seen. See who are the members of the secretary of some education department, something like that will be one of the ex officio members.
Ex officio members.
Yes.
Syndicate.
Ah.
That is section 10.
Section 10.
The very member from the project, we amended him. What has been amended? That's the.
Which is which says section 10?
Section 10, section 10 says about the members constituting the syndicate. And was the excuse. I think that has been subsequently amended.
Amended the form?
Amended by the one of the member from the one of the nominee from the director and one of the nominee from the government. They represent the syndicate.
Which is that section?
Just order section 10, but I think that was amended subsequently.
Give me the amended the provision in the Google.
Yes, sir.
Section 10 of the Orissa Universities Act.
Go and get that information from straight away from the.
That's good.
That would be my first.
Yes. Section 10. Generally, I have seen such principles and answers.
I know also that one that National Secretary is representing this bill. Check.
Say amended that updated the provisions of section 10 of Odisha University. When it is go to Google. Go to section 10. Any principal secretary of any of the department, secretary, principal secretary of the department or members of the, generally they will be. Kindly see that. Secretary to Government Higher Education Department, Mr. G. He is second member of the syndicate. Your government secretary is second member
of the syndicate.
Of the syndicate. First. Yeah. This contention is bit difficult to contain us in as much as the syndicate, the creation of syndicate as the university authority is spoken by section 10 of the Act, and the secretary to government Act, first of all. The Secretary to Government Higher Education Department, comma, Joint Secretary nominated by the government, comma, the Director of Higher Education of the government, comma, Director of Medical Education and Training, comma, Director of Technical Education and Training, and Regional Directors of Education, all from the government, and also the Collector of the Revenue District, comma, the Advocate General of the state or his representative happen to be the members of the syndicate. First, therefore, it is not that the syndicate as amended by the state legislature by a slew of amendments. First, therefore, it is not that the government did not know anything that is happening in the campus of the university. Added, the syndicate, by its decisions dated 28/10/2014 and 21/6/2017, respectively, has extended benefit of EPF and the grade pay to these petitioners. First of all, it is not the case of government that none of these ex officio members participated in the deliberation of the syndicate, nor that they registered their disagreement with the proposal. First, a slew of officials from the government are made a chunk of members of the syndicate, and they are all high-ranking officials of the government. First, therefore, this contention does not come in the way of relief being granted to the petitioners. Next one. The vehement contention of the panel advocates appearing for the university and its officials that there are no sanctioned posts, and therefore, without posts, the question of regularizing the services of petitioners would not arise, comma, is bit difficult to countenance. Firstly, it is repeatedly conceded before this court in the online hearing, personal hearing, that the services of these officials are required for the university. First off, the university could have made a request, sent a requisition to the government for the creation of posts or for approval for the creation of posts, as the case may be. First off, it is not that the government did not know that the services of these people persons is being engaged for more than a decade, and therefore, as the responsive constitutional organ, itself should have asked the university to send for the proposal for creation of course or sanctioning of course. First, there is a lapse attributable to the university, and there is a lapse equally attributable to the government. Sanctioned strength.
Yes, fine. Next to 12, page 40.
Which are those posts? Into which your services of your clients are working? Group A. Class 1, class Group B. They have in which they have stated?
Page 40.
This apart, the counsel for the petitioner rightly tells that in the RTI reply, the university has admitted that there are 980 sanctioned posts,
which includes Group A, Group C,
and of them, Group A and B posts are?
It is equivalent to class 1, class 2.
No. How many posts?
69. 69.
You have produced it now?
Yes, my lord, 40.
Yeah.
I have already annexed it.
First. As on 1/1/2023, as per the RTI information, the university has specifically stated in writing that there are 13 Group A posts remaining after abolition. Of them, 8 are vacant. First, there are 113 Group B posts and 61 of them are vacant. First, that being the position, what difficulty would come in the way of university in considering the case of these petitioners for regularization in the said vacancies remains a mystery wrapped in the first. The answer, the RTI reply falsifies the contention that there are no sanctioned posts at all. First, the RTI information record is produced as along with the application.
Yes, my lord, it is annexed 12.
As Annex 12.
Yes,
Annex 12. First, somehow this court gathers an impression that the respondent, the OPs, want to continue these petitioners with the same status indefinitely, and this is not acceptable. First, yes. That's their reply.
Yes.
That's what section officer has sent that. Yes. I have seen that. Next paragraph. The invocation of Uma Devi cannot be ritualistic. First, much law has marched post Uma Devi by the ML Kesari, and the latest one is which one? Shripad. And Shripad. Yes. This court, a division bench of this court, a division bench of this court in, is it reported? You said, has considered similar contentions in writ appeal numbers 8/7, etc. of 2024 between Orissa Water Supply and Sewerage Board versus Vijay Kumar Samal and others, disposed of wide order dated 37/2025, wherein similar contentions were pressed into service but were rejected. First, in the division bench decision, .5 power to appoint includes power to create posts also. At paragraph 6.4 and 6.5 of the said decision, it has been observed as a next paragraph. The march of law of regularization from Uma Devi to ML Kesari and to Shripad has been discussed in paragraphs 6.8 and 6.9, which are reproduced. First, in the above circumstances, these petitions are allowed. First, a writ of mandamus issues to the university and its officials who are OPs to regularize the services of petitioners in the courts, in the vacancies matchable to their stature, and grant within a period of 8 weeks, and grant all consequential benefits in the next 6 weeks. In next 6 weeks following. First, certain untrue, if not false, contentions are taken in the counter filed by the universities, as to non-availability of sports, non-sanctioning sanctioned ports, etc. And therefore, the university shall pay a cost of ₹1 lakh to which you will pay that. And this to be from the person who has sold to the affidavit. Who has sold to the affidavit of the objection statement. Registrar should pay that. Registrar. What is his name?
Present registrar
who has sworn to the affidavit. From his pocket he should recover that. Because he has misled the court in saying there are no sanctioned posts at all. ₹1 lakh he should pay. And to whom it should be paid? I am asking the bar members where they should pay. Yes.
Still continue.
No, that is difficulty. The excuse for this time. Because fact remains may submit one thing.
No, there is an attitude.
I also
to pick up all contentions like in partition suit. He is not part to me at all.
I do 100% agree with my lord. But fact remains, yes, my lord.
They have given in writing that these are the vacant posts.
But probably, my lord, there is a gap communication between the two. These people are not clearing of these things. These are the post, my lord. It includes, my lord, promotional post.
Chamber posts. They have given these are the posts.
Assistant registrar post is there. This is a group class 1 post. But it is a promotional post that cannot be filled up directly. These posts doesn't include the post these people are holding. My lord says about the matching of the post, that is a different thing. It will be an exercise.
Reluctantly, costs are not levied, agreeing with the submission of the senior advocacy sides. But I tell you, the government statutory bodies, they should stand bare before the court. They should not supposed to do all contentions taking, no power to appoint at all, kind of. In that only time is spent. Otherwise, another 3-4 matters would have been disposed of.
The only thing that my lord may say, because of this thing, my lord, in this state.
One more ground similar action of regularization has been taken in respect of several other employees, although outflow came that you just explained. With effect from the date of their initial the prayer should be initial. Generally, I would have asked them to consider, but taking unconscionable stand, I'm not sure that they will do justice to these poor people. Therefore, I said that why the direction for regulation and not for consideration? Just to explain.
Because creation of posts, etc., there could be some processing from the university to the government. They do it, whatever you want.
There are posts now. They have sanctioned.
No, that's your reply. No, that's to clarify that regarding that RTI, that those posts that they have mentioned about sanction doesn't include these posts that
look at class A and B.
No, A and B. But you also should keep in mind, librarian post happens to be a sanctioned post in the whole university, not in the Directorate of Discharge.
B. You should have taken up that contention. Madam has produced everything. You have not controverted that.
No.
What can be done?
No.
Best way is to file the appeal.
Because what your answer in as regard to RTI information, that doesn't specify these posts.
You do not they are not
defining things that I think will suffice the purpose. If that will not be befitting, the post will not be fitting to accommodate them, let them equal to the government for transfer of that post. That's exactly
that has been done in that division bench judgment.
Yes, but that's exactly that point. Actually, consider clarity.
I considered kept for today. The principal is without salary for 2 months.
Come next week.
Why not?
Tomorrow not possible because already it's and I may be in another bench also.
Only players
Some date you will stay.
These two cases are being disposed of. Only these two cases.
These 3 cases. Only 3 cases. 3 cases are disposed.
First 3 cases. All other rejects.
Others next week. Next. Obviously.